recording so that people can watch back, and for those who couldn't make it because of change of plans, etc. So I'm now going to pass over to Kirsty Horsey, who's going to introduce the session this afternoon and welcome you all. Thank you. Oh yes, I'll put your slides up. Yeah, sorry, just go to there. Well.
Hello everyone. Hello the room. Hello the room. Hello people online. So we're here today to talk about the kind of project of moving on surrogacy law. And I've given it the title moving on surrogacy, which is what we'll hear about, serendipity, collaboration and policy. And serendipity is a big part of this. So it's quite interesting really how all this came about. Lots of it was luck. And you'll hear some of this later. It started as luck. It ends up as like, you know, 11 really dynamic women driving law and policy with some guys, but maybe. So let me just, how do I do this thing? That.
And on.
Do I have to point it up or something?
And on first.
Yeah.
And then the battery is going on it. Oh, no, I'll just move on. Move you on in a second.
Cool.
No.
Sorry, technical issues. So this is dead, is it? Ignore this.
Ignore that then for now, yes. Just making sure that people can hear us online. I think so, yes. Right. Okay.
Okay, so I'm going to know that like what we're talking about, but just for people who don't know everything, I'm going to give a bit of an overview of what surrogacy is, how it works, what the law is, what's wrong with it, and I think that's about it for me. And then other people are going to come in with their sort of bit. So surrogacy, I would define it as a process where a woman, known as the surrogate, you'll notice the terminology is quite deliberately chosen, not the surrogate mother, but the surrogate in the language I use, carries a baby for another person or couple known as the intended parents. Again, the language I've chosen to use as opposed to commissioning parents or commissioning couple or anything like that. So that comes out of what comes later. Some of the research we undertook, although it was kind of always my opinion anyway. It's always nice to have your confirmation bias confirmed by your research. But that's there. So there's two forms of surrogacy generally, although there are some sort of blurry boundaries sometimes between some of those things. So I'm using the terms IVF or gestational surrogacy to mean when either the intended mother's or a donor's egg are fertilized in a laboratory using IVF, using either the intended father's sperm or donor sperm, and it might be one or both, I mean not at the same time, but one or both of the intended fathers if we're talking about a same-sex male couple. So they might both create embryos, some with one part of the sperm and some with another part of the sperm, and they may alternate or try and like exhaust one supply first and then go to the other, or not. Also, a surrogate may use her own eggs. That could happen in the IVF process. This is what I mean by kind of blurry boundaries. I think Sarah's got some knowledge of that. So it happens, so the surrogate then becomes her own donor in an IVF context in terms of the way the law works and the code of practice of the HFEA, which is the regulatory body that covers IVF in this country. So in that sense, it's still gestational surrogacy, but it's using the surrogate's own eggs in the permutations above, or more commonly, what is known as traditional surrogacy for a surrogate who uses her own eggs, which might be something like home insemination in a non-clinical setting. Next, I feel like Chris Whitty. So what are we doing here? Not a big existential question, although it is a big existential question, but here today. We're here today because I was asked to come and talk about the projects I did, which have led to some impactful research. The Law Commission of England and Wales and the Scottish Law Commission are currently jointly in the latter stages of their policy considerations about surrogacy, having done a joint review of surrogacy law, published a public consultation back in 2019, and almost 3 years later, and it has slipped a bit. There was something happened in between 2019 and now. It might have caused some delays. It was originally scheduled to be published spring 21, and then it was autumn 21, and then it was autumn 22, and now we're looking at spring 2023. So coming up, watch this space. The Law Commissions are going to publish their draft recommendations and a draft new surrogacy law, proposed bill. Obviously, there are stages that will have to come after that, such as getting support behind it, getting it into Parliament. Getting it into Parliament is quite a big thing at the moment, given the shenanigans, for better words, going on in government. So you need a supportive government. We have had that up until everything sort of went a bit messy in government. The government was supportive of this. They funded the Law Commission's inquiry and committed, as we'll hear later, to being behind it. But governments change, and so we're hoping that's still the case, and that the government will put aside parliamentary time to get this in, to get it debated, and eventually, hopefully, to get a new modern surrogacy law on the statute books. So what we have at the moment, the law is nearly 40 years old, and it doesn't, I'm speaking from my views here, it doesn't align with modern family forms, the way families are created, the way families see themselves, and how surrogacy works in practice, like on the ground, and more on that later. But crucially, we think the law does not align and does not promote, does not help the best interest of either children or their families. So children born through surrogacy, we don't think are necessarily supported in their best interest by the law, which is really interesting because the law that regulates all of the rest of assisted reproduction has the best interest of children, and family law as a whole has the best interest of children. That's a big underpinning principle, and that doesn't play out in surrogacy for many, many reasons. Even the law that governs legal parenthood, which is, so like the statutes are weird. The Surrogacy Arrangements Act, which we'll come to in a minute, is a criminal statute. The Human Fertilisation and Embryology Act is a kind of medical statute. And yet these bits about legal parenthood are essentially family law within that statute. But they date back from 1990, the original, when only married couples could apply to be parent by surrogacy, and some amendments in 2008 that extended that to same-sex couples in civil partnerships and couples in enduring family relationships, whatever that vague term means. So here today we're going to talk about the law as it stands. We'll talk about the collaborative project we've sort of undertaken as us, as 3 here, 3 online speakers. Trade strikes messed everything up, and looking ahead at reforms that are going to come in the future. So that says practice at the end. How does surrogacy work in practice? So not a lot of people know really. Like you might see something in the news or on EastEnders or whatever, and you get an idea about how surrogacy works. But really, the main bulk of surrogacy, as it happens in the UK, is driven by a number of non-profit surrogacy organisations. And I've listed them up there. Non-profit surrogacy organisations are perfectly legal, they don't make profits, they're not commercial, and 4 of them are endorsed, for want of a better word, by the Department of Health in its guidance for both people going through surrogacy and for professionals that engage with people going through surrogacy. And they, in age order, there are HOTS, childlessness, what's the overcome through surrogacy, Surrogacy UK, which is who are here today, Brilliant Beginnings, and My Surrogacy Journey. And they have slightly different models. Like I said, they're all non-profit. The law allows them to recoup reasonable costs, of doing their business. All that. So some match people, intended parents, with surrogates. Some don't, have a more sort of fluid system whereby they create the conditions where people match with each other. That's all good. And the intended parents can decide which of those, if any, they want to join and they'll do that based on their own ethos, their beliefs, their understandings of what works best for them. There's also what's known in the trade as indie routes. Independent surrogacy happens a lot. A lot of that is undertaken via various sort of web social media groups, and none of those are endorsed by the Department of Health, although there are some good ones out there. And there's quite a lot of independent surrogacy kind of collectives, if that's the word for them, who have previously worked with one of the surrogacy organisations and are just sort of going it alone because that's just easier for them in that sort of situation. But there are some independent things, and I expect you'll hear from Andrew about some situations in court where sometimes independent arrangements, because they lack the support that an organisation can give, aren't necessarily as secure or as I don't say good, but they don't necessarily have the smooth journey that you might get from a surrogacy organisation. And that's not to say that all journeys that go through a surrogacy organisation are 100% smooth. People are humans; they have ups and downs, and so it's inevitable that there are going to be some blips along the way. You can also get, and the sort of environment I'm in at the moment doing research, that is quite a big proportion compared to the research I've done before, private individual arrangements made between friends and family members. So where I am at the moment, it's almost a quarter of the surrogacies that I'm looking at are those kind of arrangements, rather than supported by an organisation. Whereas the research that we're talking about today is very, very few friends or family members who did it. That might end up being friends, but didn't start off coming together as friends. And then, of course, there are, and this is what we hear about quite a lot, people who go overseas for surrogacy. There are various destinations. Many states of America, mostly California, are sort of famous for it because they were ahead of the game in changing the law first. But then there are some more sort of problematic. Well, that's not necessarily unproblematic in North America. They've started to commercialise industry over there, profit-driven, profit-making. Surrogates are paid. Not all these things are bad. Not all these things, are even collectively bad. But it is. I mean, it's pricey. There's Canada also. I know some Canadians in the room, which has a kind of sort of weird somewhere in the middle model. It's not commercial, but it is overseas and it does cost more than doing it here. And then there are various other cases. You might have heard about Ukraine over the last year or so since the war broke out, that Ukraine was a place where lots of people went. Problematic even before the war because it doesn't allow gay couples to access surrogacy, not necessarily 100% convinced about why the surrogates are doing it. There, there's questions to be asked about lots of different overseas destinations, but while saying that, there are some good practices going on overseas. But there are also, you may have heard about Indian surrogacy, maybe 10 and 15 years ago, that shut down to international intended parents for reasons of the reputation they were getting. Also Thailand, and then it pops up in Cambodia, then Cambodia closes, and it pops up in Laos, and then pops up in the African continent. And so these things are sort of like pop-up shops, and so it's pretty hard to suppress, and that wouldn't be problematic if we knew that the women concerned were being necessarily treated well, or were doing it for the right reasons, or right reasons is very sweeping, but you know what I mean. So the law on surrogacy, as I already mentioned, the Surrogacy Arrangements Act is almost 40 years old. In a couple of years it will be. And the Human Fertilisation and Embryology Act, originally 1990, now 2008. One of the bits of the 1991 that's sort of residual. So overall, what the legislation tells us, surrogacy is completely legal in this country, despite what some people think. Certain aspects of it are not. Certain aspects are criminalised. I'd say Surrogacy Arrangements Act is a criminal law statute. So no agency, broker, or lawyer may profit. So those third parties may profit from helping arrange a surrogacy arrangement. it is not contrary to public, like what people think, illegal for a surrogate to be paid. The law does not say that, but they're not in this country. It tends not to be. That's not the model that's grown up, and perhaps because of the overall criminalisation of profit making that is built into the act. So what is typical is that expenses, reasonable expenses that they incur by virtue of being pregnant, are reimbursed by the intended parents, usually as a sort of ongoing arrangement throughout the pregnancy, sometimes as a lump sum at the end. It varies, but this includes, and the courts have authorised many different things. It's changed over the years, it's got broader and broader, but obvious things like lost earnings. You know, if you have to travel to a clinic and take a bit of work, then that costs you money, that's an expense. The travel costs themselves, the train tickets might not be very cheap these days. Things like vitamins, supplements, maternity clothes, additional childcare for the surrogate's own children, all kinds of things, and even up to things like a modest recuperative holiday. So the intended parents may agree with the surrogate that at the end of all this, she and her family, if she has one, may take a small break to, you know, reconnect, for her to, you know, chill, and you know, it's, why not? You know, so it is connected to the pregnancy in that it's a recuperation thing, but also things like spas, pregnancy massage, getting a cleaner in if she is, you know, big and uncomfortable at 8 months pregnant, you know, that kind of thing. What we found in, you know, doing research, empirical research, talking to surrogates, talking to intended parents, is that the average reimbursement is somewhere between £12,000 and £15,000. So that does mean that some people are reimbursed less than that, because not everybody incurs that many expenses, and some people are reimbursed more than that. But the highest we saw, well, that I saw in the research I did with SUK, was 25,000 thereabouts. And that's also gone out. The Law Commission did its own research, obviously took into account our research, but did other research with other people, and they're in the same ballpark as well. So we weren't making it up. It's always not perfect, all good. The other thing the law says, and this is the sort of family law bits of the law, is that at birth the surrogate is always the legal mother, whether she's genetically related or not. And she might be, and whether the intended parents are fully genetic, both of them are genetically related or not. And that's wherever in the world she gives birth. So if it's a UK-based surrogacy, she is the legal mother at birth. But also if couples go overseas, say to California, where a birth certificate will be issued in their names, that birth certificate doesn't mean what a birth certificate here would mean, and they would still not be recognised as the legal parents here, but she would, even though she is elsewhere, and the child will be here with its parents. If the surrogate, so the law continues to say, if the surrogate is married at the time she undertakes the surrogacy or in a civil partnership, then her spousal partner will be the legal father or second parent of the child, unless it can be proved in a nod to the patriarchy that he or she did not consent to their partner undergoing the surrogacy process, which is one of the most fascinating bits of the law, I think. But if the surrogate is single, I mean, you know, literally single, not separated or anything like that, but single, or it can be proved that her spouse or partner did not consent to her being surrogate, then one of the intended parents, because she will always be the legal mother, one of the intended parents can go alongside her at birth registration in this country and be registered as a parent of the child. And that doesn't matter whether they're the genetic parent or not, but it can only be one of them, can't be all three. So there are issues there. Parenthood can be transferred from the surrogate and her husband or partner, if that is applicable, to the intended parents after the birth, by the intended parents applying to the court for an order, it's a bespoke order created specifically for surrogacy, because in the old days when surrogacy first happened, you had to adopt, and that wasn't felt appropriate, even back as far as the 90s, and this new order, a parental order, can be granted to the intended parents transfers legal parenthood from the surrogate and the partner lady to the intended parents, as long as a load of conditions are met. Right, the conditions for a parental order are up there on the screen. The surrogate must consent, but she's not able to do that until the child is at least 6 weeks old. That must be free and fully informed and unconditional consent. The applicants must be over 18, which I don't think we've ever encountered in under 18 applicants. The child's home must be with the applicants. At least one of them must be the genetic parent. They must be domiciled in the UK. The application must be made within 6 months of the child being born, so between 6 weeks and 6 months. And it also says here that no money other than reasonable expenses should be given to the surrogate or anyone else, actually, the way the parental order conditions are framed. But the court has the power to authorise payments above reasonable expenses if that's in the best interest of the child. So that's where the sort of misconception that surrogates aren't allowed to pay comes from. They're allowed, but it might affect an application for a parental order if something's happened. But actually the courts have had quite a lot to say on that, and it seems that only in the clearest abuse of public policy would the parental order not be made from the basis of what money has changed hands. So parental orders are an important transformative order. The courts are very clear, and particularly in the most recent court decisions on this, that they are about giving the truth about the child's lifelong identity. What we also know about parental orders is that most criteria are met in most cases, like by miles, are totally unproblematic, and it's a magistrate who can just go, oh yeah, good, thanks, here's your parental order, hooray, congratulations. We know that where applications have been made late, so beyond 6 months, the courts are being flexible and accommodating in a purposive interpretation of what the statute says. It can't be possible that Parliament intended that if you were 6 months and 2 days beyond the birth of the child, that you shouldn't be its parents, if that would be maths. And we also know that reasonable expenses have been interpreted very generously. But also it's good practice for parents to keep records, and everything goes pretty smoothly as long as everything's smooth. So consent is probably, out of all the conditions up there, the most important, because while there have been some flexibility on many of the others, and we'll hear some of that in a bit, there is no flexibility on consent, apart from built into the statute if the surrogate can't be found or lacks the capacity to give consent. And so, I mean, you're talking, there were some cases, India in particular, where it was impossible to trace the surrogate, like they just lost, and so they couldn't get the consent, and that was the court's able to substitute its judgment in those kind of cases. But that doesn't happen in UK surrogacy because there aren't any cases where the surrogate can't be found. Parental orders, most are granted within a year of birth. I think there was a bit of a blip in COVID years when everything sort of went online. I think it was taking a bit longer then, but normally you're talking somewhere between 4 and 12 months of getting it. Although that's 18 months. Yeah, that is. And once a parental order is granted, there's a new birth certificate issued, which has the intended parents' names on it, and the old birth record is sealed away. So it's not gone forever, it's not destroyed. What's wrong with this? Well, you may have your own opinions about this, but given that we know that not very many surrogacy arrangements go wrong, despite what EastEnders and things tell you, and what we also know is that there are lots of myths out there about surrogacy. Myths, misunderstandings, assumptions. Sarah's going to give us some of those in a bit. We also know from our research that surrogates don't see themselves as a legal mother, don't think they should be the legal mother, don't want to be the legal mother, because that carries with it certain responsibilities in law, certain obligations. They don't want that. So even things like having to give medical consents at the very beginning of a child's life, they don't see that as their role, that's the parent's role. And we're talking most here, but obviously there were some people expenses, despite, again, what you might see in the media or otherwise, they're not out of control. There aren't people making fortunes out of surrogacy in the UK. And what that means, because of these myths and the perceptions that surrogacy is somehow wrong, a bit like dodge, some people have been driven overseas by exactly by what the law says, and by the myths, and by the assumption that doing it somewhere else will get them the outcome they want easier, and that's not necessarily true. So our whole thing was that the voices of the people who have actually gone through this, who were the parents of children through surrogacy and who were surrogates themselves, are missing from all this. The law from back in the 1980s was a knee-jerk reaction to a couple of cases that happened at the time, and it was like, oh no, moral panic, surrogacy, and that was the intention, to sort of drive it. But what that did was, was slow it down a bit maybe, and it allowed, on the one hand, some not so good practices to emerge, but on the other hand, it enabled some really good practice to emerge, and that's what we should be focusing on, I think, and the law should reflect the good practice that does happen and allow that to happen more, so fewer people go to more difficult arrangements. So that's backed up in our research there. It's been backed up in the later research I've done subsequently with surrogates and intended parents who are at the clinic I'm working at the moment. There's also a longitudinal study from the Cambridge Centre for Family Research that's been going since 2000, following surrogacy families. It's found that they're psychologists that found that they're functioning fine. They're all, doing absolutely well. And in comparison with other groups like donor conceived children, adopted children, and others. What's missing from all this, you might have thought, is the voice of children. And of course, that's missing because it's quite hard to get the voices of people born from surrogacy, because actually there's not many of them who are adults. What we do know, coming out more and more these days, is that there's what are they called when people go on circuit? There's a group of adults born from surrogacy who speak like brilliantly about it, about how they grew up, what they know about it, how they understand it, how they understand their parents and their surrogate and all that kind of thing, and they're amazing. And that backs up what we said as well. Like, actually, these children who are now adults are saying this, but we're still not hearing from children. So we do have another project. Me and another person at Leicester have a collaborative project ongoing at the moment, actually speaking to children. So we've done focus groups with children born through surrogacy, or whose mum was a surrogate, someone else, and we're going to compare that to children who've got nothing to do with surrogacy, and get this, the actual children's voices out there and heard. And if anyone's coming, there's a conference on the 30th of November where we will have some of those children on a panel and talking people, and some other children as well who weren't in the original project. So basically, what we know is that the law just needs to modernise. It's not in step with how surrogacy works, or how people who are involved with it or born from it see themselves. And that's kind of it. There's some further, like, if anyone wants to decide, they've got clickable links on, but this is the work we did, the two middle ones is the work we did. That you'll hear later, the green one on the right is the Parliamentary Group on Surrogacy report, which you'll hear from later. Further on the left there is a game by Zena that you can play, where you sort of, do you remember the books where you go through and it's like, do you want to enter the cave or not enter the cave? It's like that, but with surrogacy, do you want to use your own egg or not use your own egg? And you go through that, and then it tells you what the law's going to do to you. Because so it's brilliant if you want to get an understanding that way. So anyway, that's me, and I'm handing over to Andrew, who is online.
Hi, can you hear me?
Yeah.
Great. I'm waving. Is it 20 minutes I have, Kirsty?
Yes, and you'll have to introduce yourself.
Okay. I will please cut me off if I get beyond my bit, but I'll try not to.
Zaina's on the computer, she's going to tell you when you've got 5 and 2.
Fantastic. Well, I'm really sorry I haven't got a PowerPoint, but because now I realise, having had a warm-up session earlier, that I'm on a massive screen in a massive mock courtroom, and had I had slides, you wouldn't have to see my mug. But anyway, there we are. Kirsty has given a great overview, as you'd expect, of how the law is currently, and you've probably got an indication that there's the way in which the legal framework operates here in the UK essentially sets kind of traps about where the problems can lie. And as a barrister, I've been a barrister for 15 years now, and I've been doing a lot of surrogacy cases probably for the last decade or so. And I probably do at least maybe 2-3 a month, which doesn't sound that much, but actually it's actually quite a lot compared to your most family practitioners. And the common problems that I see that arise in 2 kind of key areas. The first area is the way in which the law operates, so the statutory framework, which is what I'll probably largely be focusing on in the next 16 minutes. And the other area are the practical issues, which can't be governed by the statute, but things like the issues that Kirsty was raising earlier about kind of consent, and how that can be sometimes difficult to obtain, and other issues such as the indie route of matching, how that can then set out problems if people do it informally and then there's a kind of a breakdown. But I would say from the outset that sometimes when I tell people that I specialize in surrogacy work, they kind of assume that it involves kind of your Hollywood style kind of battle between intended parents and the surrogate, and that's extremely rare. But I think it's just because a lot of the cases I do see have legal complexities where broadly there's an agreement about what should happen with the child, i.e. the surrogate wants to give the child or children to the parents, but there's some kind of legal hurdle that needs to be surmounted. And just to take, I appreciate there's a kind of a mixed, I've seen some of the names on the Zoom link, who I know will know all of this, will probably know it better than I will, and others may be less informed. But I suppose the starting point to kind of go back to where there was significant change more recently, obviously, as Kirsty has already set out, the 2008 Act broadened the criteria of individuals who could apply for a parental order, which is basically the order that recognises the intended parents as parents in this country. And it basically operates a bit like an adoption order, but it is different in the sense that it's intended to reflect parenthood rather than replace it. But it has the same effect of terminating the surrogate's legal parentage and that of her spouse if she is married. But I suppose more recently, the biggest change happened about 8 years ago when there was a case called Re-X in 2014 before the president of the family division. And in that case, he was concerned with the time limit for when you make an application for a parental order. And you've heard from Kirsty that you are required or you're obliged to apply for a parental order within 6 months of the child's birth. And in that case, there hadn't been an application made within 6 months. And so the legal issue was whether the court, the president of the family division, Sir James Mumby, whether he could interpret basically get around the 6 month time provision. And the statute basically just says it has to apply within 6 months. And cases that had been heard prior to Re-X in 2014 said that effectively you were time barred, you were stopped, you couldn't apply for parental order, and therefore you had to look at alternative routes of regulating your legal relationship with the child. But in Re-X, what the president did was basically to what we call, and law students will be familiar with this, I'm sure, from kind of first year undergraduate law, he had to read down the statute to kind of basically deploy rules of statutory interpretation and just say, well, look, what did Parliament really intend when it created this statute? Did it intend to discriminate this child or his or her parents simply by applying applying too late for an order that they might not have known they had to apply for. And he kind of says, well, look, Parliament had to have intended to arrive at a sensible decision. And when you have regard for the looking at the Human Rights Act, how Section 3 requires public bodies to act in a manner that is compliant with ECHR principles, it makes sense that we would apply it in a way that would then make sure that the act is read in a way where you can basically kind of read in words and just say, well, look, 6 months isn't an arbitrary figure. And so the corollary of that case was that the applicants, notwithstanding the fact that they'd applied beyond the 6 month time limit, were allowed to apply for the order, and they were granted a parental order. Now, the one thing I should have said actually at the very beginning is this, and it's the fact that children who are born through surrogacy, their parents, like their intended parents, they're not actually legally obliged to apply for parental order. There's no penalty if they don't apply for it. But the significant, I suppose, penalty, if there were one, is that then the child doesn't have a formal legal relationship with their intended parents. And so that can cause what some judges have characterized as a ticking legal time bomb, because the parental order, as Kirsty characterized it, is a transformative order. And so without that transformation, you don't have that concrete legal relationship. And so, as I say, you don't have to apply for it, but there can be significant consequences if you don't. And in the short term, for example, you might not have parental responsibility as a parent if you have the child through surrogacy until you get certain court orders. And so that means simple things such as consenting to medical treatment, you couldn't do without the order. So the long and short, bringing it back to REX, is that this kind of created it kind of blew open the kind of legal framework to say you can apply after 6 months. And it was really well reported in the media. And I found as a practitioner that I got all these cases kind of effectively coming out of the woodwork, where clients were saying to their solicitors, then instructing me, going, actually, we didn't know we had to apply for this. We had a surrogacy arrangement in India, in wherever, in 2007, and we haven't applied. Can we still apply? And yes was the answer, because the court's main concern is for people to get this order, for children to be the subject of these orders, rather than them not being the subject of the orders. And I suppose after REX, kind of like tracing it chronologically, the next case that comes along that was quite interesting is a case called REZ. So when Kirsty set out the change in the law in 2008, which permitted cohabiting couples, same-sex couples, and then subsequently same-sex married couples or in a civil partnership to apply for parental order, it was often thought that it was a missed opportunity not to allow a single person to apply for parental order, because of course you can have women can be treated for IVF as a single person, single people can adopt. There should be some kind of parity there. And in REZ, very similar situation where all of the criteria under Section 54 were met for a parental order, but it was a single man it was his sperm that was used to create the embryo, and he applied for a parental order, and trying to deploy the same arguments that were used in REX to say that Parliament couldn't have intended this kind of outcome to prohibit me from applying for a parental order. That can't be right. And it comes before the same judge, Sir James Mumby, the then president, and he says, look, it's really regrettable actually, because you meet all the criteria except this, it has to be 2 applicants. But I'm afraid I can't apply the same approach as I did in REX, because that would effectively be driving a coach and horses through the statute. So what he said was, look, I can't do that, but I could entertain an application for a declaration of incompatibility. Now, a declaration of incompatibility is quite a unique remedy, and it kind of comes under the Human Rights Act 1998, where you can apply for a declaration to say that a statutory provision is incompatible with European Convention on Human Rights principles if it doesn't, if there's some form of clash. And in this case, in Re Z, there was a second case where the would-be intended father brought an application for a declaration of incompatibility and essentially said, look, it's a breach of Article 8, which is a right to family life and privacy, and a breach of Article 14, which is a right to not be discriminated against. And of course, the government were then a party to the proceedings. I was junior counsel representing the child. And in the end, the government agreed that it was there was an incompatibility. And I won't go into the reasons why, because it's a bit more technical. But the point being, a declaration of incompatibility was made. And then I mean, gosh, that was 2016 when the case was eventually heard. And we've had about, what, 1 million prime ministers since then, and so many different governments since then. I can't remember what happened. But essentially, there was then have to be a remedial order is then made once the declaration is made. And the remedial order came into force, I think, in January 2019, that now permits a single person to apply for a parental order. But crucially, they have to be genetically related to the child. And if they're not, then you can't get a parental order. The other area that has kind of come up as an interesting point is, in terms of the statute, is the definition of an enduring family relationship. Again, you heard it outlined earlier by Kirsty, that the 2008 Act allows for people who are cohabiting, essentially, well, cohabiting is actually the incorrect word to use because the statute says enduring family relationship. And I think what people conventionally think is that means two people who happen to be living together, but aren't married or aren't in a civil partnership. But the Act doesn't talk about cohabitation at all. It's completely improper of me to say that, and all the academics in the room will be screaming at me, and I'm sure Spencer from the Law Commission would be screaming at me too. The Act says enduring family relationship. But I think, as I say, what people think that means is that it would be, as I say, two people living together who just aren't married or in a CP. The first case that dealt with an enduring family relationship was in 2016. It was a Thai surrogacy case where Ms. Justice Russell basically says, look, Parliament didn't specify or define what enduring family relationship means. It's a question of fact, i.e. it's a matter for the trial judge to determine, and he or she can work out what an enduring family relationship means. Now, again, you might have thought that then means, well, 18 months, 2 years, that's probably about enduring, and that would be enough. But actually, since 2016, there have been a number of cases that have really kind of shattered that concept or that kind of perception that actually enduring family relationship can come in all shapes and forms. And in fact, there have been cases where they've not really been a couple as such, and it's two individuals who have entered into a surrogacy arrangement. In fact, one case, it was a gay man and a straight woman, and the court still made a parental order, but characterized their relationship as being an enduring one. And so it's not a kind of a concrete definition. Of course, enduring is quite a broad one. And as soon as you get into the realm of it's open for the court to determine what it is, it allows the court a bit of elasticity in terms of how it can interpret it. Because ultimately, if the court doesn't make the order, then it's going to be prejudicial to the child and his or her parent. So the court will try and find a way to get around it. And then the other area that I think is quite fascinating to look at is the definition of home. And this is a bit of an odd one because the statute says in section 54(4)(a) that when you make the application for a parental order, and when the order is eventually made by the court, the child's home has to be with the applicant or applicants. Now that, again, a literal interpretation of that sounds as though it means it would be, as it says, I live here in my house. When I make the application, the child's home has to be with me here in my house here. And then when the order is made, the child's home has to be here too. That, again, has been kind of completely blown out of the water. And the kind of the spoiler, the short note to what the courts have said in recent cases, the main one I would probably draw your attention to is a case called Re A from 2010, sorry, 2020, like a case that I was in, where the court basically just said, look, you've got to give the meaning of the word home a really broad interpretation. And in that case, the intended parents had separated. They'd separated before the child was born. The dad wasn't even having any contact with the child. So I think, in fact, I think he was having supervised contact. And so the child hadn't even really been to his home. But the court applied ECHR principles, looking at Article 8, looking at the meaning of family life, and applying ECHR jurisprudence to say you've got to give it a broad and purposive interpretation so as to give effect to that Article 8 right. And of course, if you don't do any of that, you don't get the order, and then that's bad for the child ultimately. It's to his or her detriment. The other issue, just to kind of look at where you can get difficult, is consent. And I think, and as Kirsty said, that is the only issue really where it is just a non-starter. If you don't have consent of the surrogate, you're not going to get a parental order unless you cannot find her or she lacks capacity. And the provision to dispense with consent is an interesting one, because there are lots of elements where the approach taken by the court is very similar to that of a court dealing with an adoption order. And when you're looking at adoption orders, the court has the power to dispense with the birth parents' consent if it's in the child's best interests. That doesn't arise in surrogacy cases. The Human Fertilization and Embryology Act does not have that provision to dispense with consent. And so if consent isn't forthcoming for whatever reason, even if the court considers it's in the child's best interest to make the order, it won't do so, because it can't, because the statute just says that. And I think it's seen that the consent element is seen as a bedrock to the statute, and so you can't really just kind of override it. And as Kirsty alluded to, there's a few Indian cases in the early 2010s that dealt with this. Like, one case is called Reedy and L from 2012, where the then Mr. Justice Baker says, if you're going to dispense with consent, you've got to have exhausted every avenue before we will consider dispensing with consent, because it's a big deal. And when the surrogate engaged in this arrangement, she knew, it could be said, or she should have known, that she had the power to withhold that consent. So you can't just dispense with it kind of willy-nilly. And so you've got to go through a really kind of rigorous process. And it's a process I'm familiar with, having done it in a case recently, or in the process of doing it, where you really need to kind of demonstrate to the court that you've exhausted every possible avenue. And so that is a classic one. And then I think I've got 2 minutes left, so 2 very quick areas where, in fact, I have got 2 minutes left. 2 areas where you can, other areas that are of interest are payments. Payments is under section 54(8) that basically says, look, you can't, you have to pay reasonable expenses in terms of the surrogate's expenses. And then if you've got to have a commercial situation, you can, the court has the power to retrospectively authorize that. When it comes to reasonable expenses, there's no kind of figure, but of course reasonable means reasonable, and that's needs to be specific to the circumstances of the individual. And then the second kind of area, just to very quickly raise, and it's a point that I think hopefully might be dealt with later, is in some jurisdictions such as California, you can go there and commission a surrogacy where you or your partner are not genetically related to the child. So it's a donor egg and donor sperm. In those circumstances, those intended parents, when they come back to this jurisdiction, they do not qualify for a parental order. And so they kind of fall outside of that kind of legal framework. And so if they want to be recognised as parents, there's a whole other route they have to find some kind of short-term or long-term provision. And one of the ways of doing that has been either they might kind of apply for an adoption order in America, which then might be able to be recognized here if they meet certain criteria. But that's an area that's can be quite complicated, and I think it's often kind of forgotten about. So I think I've counted through that quite quickly, and by my time I've got 7 seconds left, but I will close there. So happy to answer any questions later.
Thank you very much, Andrew. And now we're back in the room with Sarah. You can be consulting now. You can down to
So surrogacy myths is on this one. Not that one though. We want oops. Hang on a second. Get rid of that one. Is that one? Is that the one?
Yeah, that's the one.
Sorry, and then I've just got to do this. There we go.
So hello everyone, my name is Sarah Jones and I am a representative of Surrogacy UK. I'll tell you a little bit about me. So I joined Surrogacy UK in 2002, which means I've been there 20 years. I've been a surrogate 5 times. I've used my own eggs 3 times through home insemination. I've done hybrid straight surrogacy by donating my own eggs at a clinic and then them being fertilised and then put back in me for my IPs. And I've done completely host, so my intended parents, full embryos for my last journey. So I've done all. Yeah, that's it. That wasn't. Sorry, can I go back a bit?
Oh, sorry.
I mean, I should remember who I am, but just need the slides. I've been a support worker at Surrogacy UK for a long time, probably about 15 years, and that's supporting intended parents and surrogates and completed families. I also sit on the board of trustees at Surrogacy UK, and I'm now the head of surrogacy at Surrogacy UK. Thank you. So I'm going to talk to you a little bit more about surrogacy myths. I'm going to talk to you about myths from a sort of a personable angle, I suppose. So I will run through some of the myths that there were about 20 years ago. So at the time, 20 years ago, it was heterosexual couples that were coming to surrogacy. And the myths were that intended parents just wanted to use a surrogate because they were wealthy and they could afford it. They were too posh to push. They didn't want to ruin their own body by going through a pregnancy, and they wanted no relationship whatsoever with surrogates, and they wanted to keep it a secret. They could keep, you know, they could pretend that they carried the embryos themselves, and they were going to do very secretive with their child about their origins. In reality, even 20 years ago, surrogacy was seen very much as a last option for people who had exhausted every other option for surrogacy. They had been through IVF multiple times, you know, they'd experienced loss and stillbirth and things like that, or they had a medical condition that meant it was impossible for them to get pregnant. And in reality, those were the people that were coming to surrogacy even 20 years ago. You know, the myth that they had to be wealthy, the rich intended parents swooping in and paying a surrogate to have their baby, it's just not true. You know, most intended parents are pretty normal. They have normal jobs. They have a normal salary. I would say they may well have more money than a surrogate, because they haven't got any children. And probably anybody that doesn't have children is a little bit better off than people that do have children. On the whole, I would say. So these people, intended parents, normal jobs, normal salary, saving up, taking out loans, you know, doing whatever they can to afford IVF and surrogacy. And they did want openness. You know, they, even 20 years ago, they looked at lessons learned from the adoptive community about what was upsetting to children born through adoption, and it was the secrecy. It was never being told. It was finding out at a late age that they were adopted, that actually was more damaging than the fact that they were adopted. And so the surrogacy community in the UK really took that on board, and especially at Surrogacy UK, openness and transparency was one of the, the key values that we have, and that was really embraced by the intended parents. They wanted to be open about their child's origins. So that's some of the myths. Then same-sex couples could access surrogacy, and we had a whole load of new myths coming. So same-sex couples obviously only wanted a child because it's a fashion accessory. It was the next step up from a chihuahua and a nurse, I don't know. But that was that argument is still used now on social media. If you look at Tom Daly, who has children through surrogacy, but always it's said, oh, you just want a fashion accessory. It's the latest thing for same-sex couples to now have children. So that's a myth. The myth is that they are using women's bodies. That's always talked about, and that same-sex couples should adopt. In reality, men are loving and nurturing caregivers. They have the same biological want for children as mothers do. There is no difference between men and women in that want to have their own children. So that's the reality of same-sex couples using surrogacy. Thank you. So yes, so why don't they just adopt? Is something that's wheeled out in every discussion, in every argument about surrogacy that there's ever been. And adoption shouldn't be about finding a child for a childless couple or a childless parent. That's not what adoption should be. Adoption should be finding the right family for that child. And shouldn't everybody consider adoption before they have their own children? If they want, if there's that many children that need a home, why is it just the infertile and same-sex couples that are always said, why can't you adopt? It's not their responsibility, it's everybody's responsibility. So this sort of is still now thrown about, this myth that people should adopt before undertaking surrogacy. Nobody ever asks people going through IVF whether they want to adopt first. Anybody that's lucky enough to be able to conceive their own children, it's never a question. Nobody ever asks them. So this is one of the biggest myths, is that intended parents should be adopted before surrogacy. I don't know. Thank you. So this is one I like talking about, and everyone's always talking about. Who acts as a surrogate? So what sort of people act as surrogates? So the myths are that we are from a lower socioeconomic background. Again, there might be a pay disparity between surrogates and intended parents, but that's because for the most part, we have children. So we are going to have less money than some IPs that don't have children. We are vulnerable and we need the money. That is one of the biggest myths that we are taken advantage of because we are poor and we're doing this just to survive, is a myth. I would say that that's come from other countries like India, like Thailand, is that yes, there are women in other countries that do pursue surrogacy for money. It is seen as a way of making money for themselves and their family, and for them it's a considerable amount of money. In the UK, that's not how it is. Surrogates on the main part don't need that money. They have jobs, they have careers, they're normal parents, and they are doing this for other reasons. There is a perception that surrogates are uneducated or have a lower education, and that's why they're undertaking surrogacy. They're not informed, they don't understand what they're doing. The other one that we get called quite a lot is that we're cold-hearted baby sellers. That's pretty nice. The one I didn't mention on there is that we're glorified prostitutes. That's the one that's always banded around. We are using our body for monetary gain, and we are prostitutes. That's definitely not what we are. There is another myth that we must be being coerced by somebody for financial gain. Usually the example given is that it's a partner that is coercing us into doing it so that we can make money for them. There's a myth that surrogates have no choice in what they're doing, and I'll talk a little bit more about that later. And then the main myth is that surrogates must want to keep the baby, must. You know, in this society, there is no way that a woman can carry and give birth to a baby and then not fall madly in love with it and want to keep it. I think that's quite offensive, to be honest, that I'm not able to make a decision without my hormones messing it all up. You know, really offensive. And statistically, the amount of surrogates that have gone on to keep a baby over the last 20 years, maybe 4, you know, statistically, it's just not a thing that happens. There are surrogates that have opted not to sign for the parental order, not to consent to the parental order, but do not wish to keep the children themselves. So there's a control element to those cases. It is not about falling in love with the baby and wanting to keep it. It is more about control aspects. The surrogates that have gone on to keep the baby, most of the time happens is there is contact with the intended parents and the surrogate. So they both have access to the child, and they're both raising the children. And I think it's a bit of a myth that the surrogate, quite frankly, I mean, I'm sure Chris might talk about this, that there's a myth that the surrogate has the right to keep the baby. You know, nobody has the right to a child. You know, courts will always act in the best interest of the child. So, you know, there isn't a right to keep the baby. But yes, but in the reality of surrogates is that they volunteer. So you can't advertise for a surrogate. You can't advertise to be a surrogate. Not-for-profit organisations cannot advertise asking for surrogates. So the surrogate really has to go through quite a lot of hoops to be able to be a surrogate. They have to volunteer. They have to come across that information themselves. They have to do their own research. They have to become informed before they can even become a surrogate. Again, if you look at countries like the Ukraine, where surrogates are targeted in their communities as this is an option for you. You can make money by doing this. So surrogacy agencies will go to poorer communities and, you know, present that as an option. That just doesn't happen in the UK. We're not allowed to do it. It would be unethical for us to do it. And to be honest, the surrogacy community in the UK are actually quite ethical in that it leaves a very bad taste in all of our mouths to be doing something like that. And you'll see from all of the organisations, not one of us advertise surrogates. You know, not one of us, you know, put ads on the internet saying you could make X amount of money by doing surrogacy. So for UK surrogates, it's very different. They have to be self-motivated. They have to come to surrogacy willingly. They have to do their own research before they even start a surrogacy journey. So surrogates do have altruistic motivations. They don't earn a living from surrogacy. They know that. And I could probably count on one hand the amount of inquiries that Surrogacy UK have had from surrogates that note that they need money as the reason for doing surrogacy. So over the last 20 years, it's a handful of people that have thought that they could make money from surrogacy and have come to Surrogacy UK. That doesn't fit in with our ethos, and they wouldn't be accepted at Surrogacy UK to be a surrogate. So we would not accept anybody that had those motivations because it doesn't fit in with the parental order requirement. Other motivations that surrogates have is they particularly want to help somebody from the LGBTQ+ community have children. Lots of surrogates have experienced their own infertility and have had to go through IVF themselves, and they see it as giving back because they have been successful at IVF and they want to help somebody else. We have a large number now of child-free surrogates coming through, and that's women that want to experience a pregnancy, don't want to have a baby themselves. You know, they're really interested in how that's going to be. And our first child-free surrogate that we took on at Surrogacy UK, she's on her 6th journey, and she still has no intention of having children. She doesn't want to have children, and that's pretty much part of the course for our child-free surrogates. They're very strong-minded. They know what they want, and they know what they don't want, and they definitely don't want children. So, surrogates on the whole are very strong feminists. I know maybe 2 that don't count themselves as feminists, but they are really, they're just, you know, they don't get involved in all of that. But surrogates on the whole are very strong feminists. It's my body, I want to do what I want to do with my body, and nobody should be dictating what I do with my body. We're very vocal. We're very vocal. Somebody once described our surrogates as very militant. I'm quite proud of that. I'll be honest. We are very vocal about our wish to become surrogates and the reasons for that. As I said, most of us are working or have careers. We talk a lot about how surrogates are on a different income than intended parents, and I don't think there's a correlation with that, in that they're on a lower salary, so they have to be surrogates. I think the type of people that choose to be surrogates automatically veer towards different professions. So we have a lot of surrogates in caring professions because of the type of people that they are, that want to volunteer to do something for somebody else. They're automatically drawn to teaching profession, nurses, midwives. So professions that actually are paid less in general. But I think that's more of a personality type rather than I want a lower salary, so I have to do surrogacy. So, you know, we certainly have surrogates that are solicitors and GPs and, you know, managing directors, things like that. But, you know, the majority of our surrogates are in those sort of caring professions. Surrogates are caring, we're not cold-hearted. We have lots and lots of love for the children that we carry. You know, we have relationships with them, we watch them grow up, we're involved in their families. It's just not maternal love. So if you think about, I don't know, a niece or a nephew, or your best friend's baby, you know, you love them to bits, you do anything for them, but it's not maternal love. And that's how surrogates see it as well. Surrogates do have ongoing relationships with the families. The children born through surrogacy know who their surrogates are. They know their story. They embrace, you know, being born through a surrogate. One of my surrogate babies is now 9, and his dads were talking to him about where he gets all his best bits from. You know, where does he get his hair color from? And they sent me a little video, and they sort of said, Elliot, where are all your best bits from? And he went, Sarah. So like, I agree. So that sort of openness and transparency in those relationships continue in UK surrogacy, which I think is really, really quite unique for surrogacy across the world. Is that there's that expectation that the children are going to have parents and a surrogate through their life. And yet surrogates do not want to expand their own family. They do not wish to keep the baby. If they wanted to have a baby, there are a hell of a lot easier ways to have a baby than to go through surrogacy. Surrogacy is not quick. It takes a long, long time. It takes years. Elliot, who I gave birth to 2 years ago, we took 2 years of IVF to conceive him. If I wanted to have a child of my own, I would just have a child with my partner. It would just be as easy as that. So surrogates don't want to expand their own family. Thank you. And the biggest one for surrogates in the UK, which again is quite unique to surrogates in the UK, surrogates have control over their own surrogacy journey. So surrogates have to volunteer, like I've explained before. Surrogates choose who they would like to help, especially at Surrogacy UK. They're not matched at Surrogacy UK. They can talk to as many intended parents as they like and see which friendships grow from those meetups and conversations. They choose who they would like to help. There's no pressure, no rush to choose. Some surrogates have been with us a couple of years before they meet the right intended parents. You know, there's no rush. Surrogates retain their body autonomy, which is a big one for surrogates in the UK, and it came through very strongly through the Law Commission consultation. Surrogates do not want to be told what to do with their own body. They want to make their own medical choices. They want to give birth in the way that they wanted to. We saw the contracts that came from US surrogacy, which dictated how far away they moved from their house, when they could have sex with their partner, whether they could colour their hair, or you know, what they could eat, whether they could drink coffee. And surrogates in the UK went, no, we're not doing that. That's not for us. So we really spoke out very strongly about keeping our body autonomy. It is your baby, but it's our body, and they have to work together. And ultimately, the surrogate is in charge of all her medical decisions, how she gives birth. And then the last point is surrogates are legally responsible for any child they give birth to, which is not something that we want. I do not wish to be legally responsible for somebody else's child at any point. I don't wish to be asked if somebody else's child can have a medical procedure. I don't want to sign somebody else's child's passport form. I don't want to register the birth of somebody else's child. They should be decisions that a parent makes. Yeah, thank you. I'm going over a little bit, sorry. I'm just going to go do this one really quick. So these are the new surrogacy myths that are coming out. We've tried to dispel as many of the old ones as we can, but the new surrogacy myths are centred around solo intended parents. Lots of people understand why women want a child outside of a relationship. Sperm donation and being a solo female parent is completely acceptable in the UK, but there's a lot of talk about why do men want to have a child by themselves? You know, in particular, you'll see on forums, lots of journalists are asking lots of questions about safeguarding, because they believe at the moment that single intended fathers have some criminal motivation for having a child through surrogacy. The fact that they think they're all paedophiles is really quite offensive, but that seems to be the newest myth that's happening in the surrogacy world. But obviously, in reality, men like women also want to have children. Men like women shouldn't have to wait to meet the love of their life before they have a child. They should be afforded the same rights as a solo female parent to access IVF and to have children. And with regards to the safeguarding issues that people have, there are lots of easier ways for men to have a child and get access to a child than trying for years to find a surrogate and go through IVF and all of that. So that seems to be the newest myth that unfortunately is doing around. Thank you. So they're my contact details if you need to contact me. But yeah, that's it. And I think I might be really
Right, so we've got time for some Q&A now before a break. I can't remember what time the break's going to be.
4 o'clock.
Break at 4, so we've got 14 minutes of questions. Is Andrew, can you call Andrew back on the screen? Hi, Andrew. Make his face really big again, Dan.
Make his face really big again.
That's really cruel. At least I can't see it.
So yeah, does anyone have any questions for either Andrew, Sarah, or me before the break and before we go on to the other talks? Well, if not, we'll break in. Hannah, you must have a question.
Well, I do, but it's I actually have a question for Andrew.
Can you hear this, Andrew?
Okay, can you hear me, Andrew?
Yeah.
Okay. And it's I just would like to know if you have encountered or have come across some of those really difficult cases where there are surrogates in Ukraine who had intended parents in the UK. And the difficulty of either getting those children out of the Ukraine, and also some of the surrogates, of course, wish to be evacuated from the Ukraine and have a baby in the UK or Poland, or well, not in Poland because that was a problem for the citizenship and parenthood. But I just wondered, has that come across your plate yet?
It has. Thank you for that question. It has come across my plate, but only cases where the child was, or children in separate situations, were born prior to the inception of the invasion. I think one was actually quite close to the invasion, and in those circumstances, in fact, both of them, the intended parents managed to leave Ukraine and come back to the UK. But what has happened in terms of the difficulties is that there is a real lack of paperwork from the Ukrainian authorities because the process wasn't completed. And there's also, I have to be careful because of course some of these cases are still live, so I can't really disclose too much. But it has created a difficulty in terms of the paper trail because, for example, you can imagine if you're trying to register a birth in Ukraine, it's quite difficult, if not impossible, particularly at certain times. And then that then becomes difficult if the intended parents have returned to this jurisdiction. They're not necessarily want to go back there in a hurry. And so in some cases, it hasn't made it insurmountable to get a parental order. And in some situations, there have been difficulties for other reasons. But I know some colleagues have had cases, and I think, of course, there was a quite a big, a very positive campaign at the beginning where the Home Office had made provision specifically, I think, for surrogates, where they could basically be fast-tracked to come to the UK and could acquire status here to have the child delivered here. But of course, the other problem actually that has occurred is, well, again, I've got less experience of this, but I've heard about it on the kind of the grapevine, is that women, of course, have been displaced from various locations in Ukraine, and then they may have gone to seek refugee status in neighboring countries. And then, of course, the problem that might then happen, one can imagine, is that they go to Poland or they go to Hungary or they go to Romania and they deliver a child there, but then the statutory framework in that jurisdiction isn't one that recognises surrogacy. So then you have another complication as well. And so it has been quite difficult, but not necessarily impossible, but it's just caused kind of more problems. So I hope that kind of answers the question.
Natalie had a question.
Am I allowed to?
Yeah.
I have a question for Sarah actually, just on the further from it, a bit of what we were talking about before, but is there a potentially new myth, and it links back to almost some of the language at the beginning as well, that a surrogate might not identify as female?
Yeah, we have transgender surrogates within Surrogacy UK, and we actually don't use the phrase when we talk about surrogates anymore. We talk about person people, with that group that like to term pregnant people.
It's raising motherhood.
Yes, not erasing anybody else's motherhood, I'm just erasing the surrogate motherhood. For years, we've not wanted to be called surrogate mothers and wanted to be called surrogates because they're not the mother. But the term pregnant people really works for our group because that's very inclusive. And yeah, we do have trans men that are currently pregnant and caring for other people.
Just to say, Sarah Norcross on the chat has said the working group worked with Andrew Percy MP to help persuade the Home Secretary to fast track entry of surrogates and their children to the UK from the Ukraine.
Thank you, Sarah. Is that other questions come through on the chat there?
And that's the only thing that's come through the chat, nothing else so far.
On there.
And that's me sending messages saying to people, can you please give us some questions?
Yeah, if someone online does have any questions, feel free to put it in the chat,
Or just turn on their camera and speak.
brave enough and ask it. Are there any other questions in the room before we?
No, there is one online very quickly. Andrew, is there a way that the court differentiates between a commercial payment and a reasonable expense, considering payments for holidays could be included as a reasonable expense?
It's a really good question. I mean, look, I suppose the question is always about reasonableness, and I suppose what the other approach the court has to take is, when looking at whether something is reasonable, is whether it has the potential to kind of overbear or kind of change the position of the surrogate. Now, if you've got something that is complete in terms of giving consent, now if you've got something that is completely kind of innocuous and it's just a kind of a nice gesture, or perhaps characterized, as I've seen, as a kind of a relaxing break, having had 9 months of pregnancy, then that is likely to be considered to be reasonable and not unreasonable. But it's where, for example, if it was then became something completely extravagant and kind of over the top, it might be seen, or it could be questioned as being something that might be seen to kind of be not being reasonable. And I suppose the important thing to remember throughout the parental order process is that automatically what's called a parental order reporter is allocated to the case, and he or she is a individual from CAFCAS. So they are a court appointed social worker, and they've got a duty to kind of consider this as well. They're a bit like the court's eyes and ears on the ground, and if they've got something which they've kind of raised a concern about, they're likely to kind of flag it. But on the whole, I mean, I've not seen a case, and I'm sure I'll be correct if I'm wrong, but I've not seen a case where the court has said, we're not going to authorize this because it seems there's a question of it kind of inducing consent or something. And generally, for there to become a breach of public policy, it has to be pretty high, because ultimately it means you don't get the order if it's not made. And so there's a case actually kind of on point with this that I dealt with recently, that it came out this week, in fact, called I forgot what it's called actually, YMP, I think it's called. And it's a case where there was a question about whether the money that was given to the surrogate at the same time for a birth certificate, I think it was $5,000, was conflated with being money for the surrogate to sign the consent form. And fortunately, in that case, there was an evidential trail which the court was able to make a finding to say, well, actually, there's independent evidence that says that money was specifically paid as the surrogate was contractually due in that country for the birth certificate, and it was distinguishable from the payment from any payment for consent, because that would be seen as being unreasonable. So it can get a bit tricky, but ultimately, you've got to have your kind of common sense hat on when you're looking at what is reasonable.
Thank you very much. We had a question in the room.
I have a question about commercial. So it's always seen as commercial service as we're using women's body, so it's like people with poor countries, the prayers and my concern is, and between ethical and unethical, I came from the Middle East, where almost all the countries is banned, completely restricted, apart from Iran, which is in Iran, Syria, unregulated countries like Egypt, Lebanon, so people do it secretly. My idea is that there are many women who they don't have any support for their family. So the government they can't support. Their regulation is they don't also give them any kind of keeping their rights for anything. So they go for surrogacy. Yes, it is commercial,
but then they don't have any other way. So it's kind of, they help their families. So when we regulate this, when we ban commercial surrogacy, we block this for them. And we don't offer something else in return. Well, I'm not completely saying that commercial surrogacy is it, but when governments are not giving women support, and they have to take care of their families, and they have to support their families. And this is, in some of the cases, this is the only way, and they get sufficient amount of money. And in the same way, they think about it like we are helping people. So it goes both ways. They help their families and they help another family. So I personally struggle between finding this ethical orphan, because who we are to say like, no, surrogates, they shouldn't take money for the service. It should be completely understood, while we don't know their social circumstances. So I don't know, like, if there is anything like we can think about it, like how really unethical is commercial service.
For me, it becomes ethical when somebody has to do something. So it's ethical, for me it's ethical if somebody wants to do it and can switch voluntarily. If the onus is then that they have to do it to win women, then that's where ethics comes in. So I don't personally think anyone should have to do anything with their own body to be able to win women in that way, but it's like in the States that there is a commercial model, but it's the ethical commercial model, because surrogates in the US cannot be on any sort of state benefit. They have to prove that they have an already current standard of living before they're allowed, before they're eligible to be a surrogate. So commercial surrogacy can be ethical, but again, it's showing that surrogates want to do it and are choosing to do it rather than have to do it, to support the family. So that's my personal opinion. I'm not sure I have a solution.
I personally struggle with that. Looking at the cases where, especially where it's not legal, specifically looking at Egypt. So it's completely illegal, socially not acceptable, but then still surrogates, they choose to do this service to people so that they would get money. And I totally understand. It's like using something, especially when they're not educated. Yes, I understand, like in the UK, it's different. But in the Middle East, where you have an uneducated woman, she has children, her partner left her, she doesn't get any benefits from the government, and this is the only way she's seen as ethical. I'm not doing prostitution, I'm just helping people and then I would take them. So
I think there's a difference between commercialism and motivations. So I think in that situation, there can be the motivation can be both altruistic to help somebody else and desire to help one's own family, and that kind of thing. And the pressure of the individual economic circumstances of the woman is not, it's not about surrogacy, that's about the society that she's in and the support, like you say, she's not getting otherwise. Where I struggle with commercial surrogacy is where the whole thing is commercialized and other people are making a lot of money out of people who might not want to, or still, I mean, they're still motivated by altruism, but they maybe are, something is making them be surrogates when they otherwise wouldn't have done that. And the fact that other people make a lot of money out of that sometimes is when I start to bristle against the ethics of it all. So sort of, even I know in some sort of unregulated places, there are people who act, shady underground surrogacy brokers. And in fact, there's been some cases in the UK where we can see from judgments that there's some people out there who aren't in surrogacy for the right motives. And that's where I start from it.
I think the US surrogacy as well, the person that makes the least money for it, the whole arrangement, even, $40,000 is sort of is particularly high for sort of debt, whereas US surrogacy can cost $150,000. So practically, the surrogate isn't actually the person profiting the most from that arrangement.
As well, I mean, it's a slightly different way of looking at it, not so much in your specific example, but it's also for me in the UK context about access as well. Once you start changing culture and normalising commercial surrogacy, you are starting to introduce barriers to access to this form of becoming a parent, because you're going to be getting kind of costs, and it is going to be transformative of culture as well. So I think there's another perspective. It's not just commercial surrogacy and ethical practicality in the UK. It's kind of taking a more holistic look. So what would the consequences of commercial surrogacy be on the way that surrogacy works in the UK? What is, I think Kirsty, you said, what do we want to protect? What is the practice? What is the values and the vision that we want for surrogacy? We want it to be effective, we want it to be effective. And actually, where would commercial surrogacy potentially put barriers up for access to surrogacy?
I have another question if you've got time online. And a message from question from Christina at CHIP, Child Identity Protection. Hi, to what extent is the child's original identity and new identity, i.e. parentage, fully reflected in birth registration and certificate in the UK? What about surrogacy arrangements abroad?
Andrew?
So, yeah, thank you for that question, Christina. So on the so basically, what if it's an international situation, you will probably, hopefully, get a birth certificate in that jurisdiction, and if surrogacy is recognised there, such as somewhere like California or even Ukraine or other Canada, that birth certificate will say who the child's parents are, and it won't include the surrogate or her husband. And then when they come here to this jurisdiction, you apply for the parental order and you're reissued with technically what's called a parental order certificate, which looks like a birth certificate, but then names the intended parents as parents. If it's a domestic surrogacy, and I'm hoping Sarah or Natalie will correct me if I'm wrong, as I understand it, the birth certificate, the UK birth certificate will say the surrogate on the birth certificate as it is at the moment, and her husband if she's married. And then when the parental order is made, the intended parents are then given a parental order certificate, which effectively replaces the original birth certificate. And as I say, the parental order certificate basically looks like a birth certificate. And so that would be the document which is then used as a form of identification to demonstrate a relationship between the intended parents and the child. Sarah, Natalie, do you agree? Is that about right?
I think so. My kids are now nearly 12, so I'm having to cast my but yeah, from what I remember, I think the new birth certificate was issued has like a little reference in the corner to show that there was a previous birth certificate. So yeah, there would be that connection back to the original birth certificate. Yeah.
So hopefully that answers the question for Christina.
There is an audit trail for the
yeah.
Thank you. That's it.
Yeah, thank you very much. We've got 15 minutes break now, but it's 10.
So did you want to do it for 4:20 or?
Okay.
Thank you very much.
4:20 back.
Well, hello everybody online. We're just about to restart. So when you're ready. Yeah, I don't know.
Hi, welcome back, both in the room and online. We're going to carry on with the second part now, starting with Natalie, who is back in the room.
Hi everybody, my name is Natalie Smith. So my background, I was an intended mum, now just a normal mum, to two little girls who were born through surrogacy. they were born in 2011, so they're now maybe 12 years old. So my surrogate journey was quite a long time ago. The bit that I'm talking to you about today is more kind of flipping to the, well, we've heard a lot about what's wrong with the law, so how have we started to try and drive the momentum to change things? And I'm going to really focus right back, I'm going to take you back to 2014, 2015, which is when a lot of the people that you've seen today kind of came together and joined forces. So the bit I'm specifically going to lift out is why we set up what we called, we need a better name really, it's a bit boring, but the Surrogacy UK Working Group on Legal Reform, not very catchy. We tried to find an acronym, but that wasn't really working either. So kind of why did we, the main things we're going to cover is kind of why did, and I kind of helped set that up. So what motivated me to set up that group of people? What did we want to achieve? What was our kind of vision? What did we want to do? Who became involved with it? And why did we gather that particular group of people together? And then finally, kind of what then were our quite specific objectives. I'm not going to go into the detail of the campaigning because I think Sarah's going to cover that after me. So it's more about just that setup period. So back in 2014, probably the reasons that I decided to set up the working group were twofold. One was quite personal to do with my situation at the time. So my twins who were born through surrogacy had just turned about 3. I'd come out of the fog of sleep deprivation and not being able to think about anything, and hadn't returned to work yet, and was kind of wanting to give back to the surrogacy community. And 100% the reason that I wanted to go back to SUK and give back was because I was really quite changed by the women that I've met who are the surrogate, people like Sarah, the surrogate who helped me, Jenny, and there were a few other IPs as well. Remember, there was a lady called Emily who had done a lot of campaigning, and unfortunately she passed away from her illness, and not on surrogacy campaigning, but for her health condition. And through surrogacy, I just met this community of amazing women who were doing so much to do something they really believed in with real purpose and to give back and help others. So I kind of thought, you know what, I want a bit of that feeling that they've all got. I really want to do something. So I went back to SUK. I've been volunteering at SUK throughout. I've been a support worker for other couples, but I joined the board of trustees there. And then just around that time, so I was in that kind of position where I wanted to get my teeth into something, wanted to do something. And there were some noises coming through around changing surrogacy law. And that was great because obviously having gone through it and helping other people go through it, we're very well aware of the downfalls of the current law. And, you know, Kirsty mentioned that my parental order took, I think it was 15 months to come through. There was no reason for that. It was just administrative errors. The wrong CAFCAS report was made, the wrong court thing was made. It just was a bit of a mess. And, you know, going through that whole process, obviously wanted the law to be changed. So that was good. But there are also a few things about the way the conversation that was happening that we just thought, oh, it doesn't feel quite right. And there were a few different problems. One of the main ones was that there didn't seem to be the voices of people who'd actually gone through it, that were really at the heart of that call for change, or that were really being reflected in those calls for change. So what was really missing from the conversation was the voice of intended parents, the voice of surrogates, which I think is probably the most important one in that context, the least well understood one, I should say, so the one that needed to challenge a lot of conceptions, and also the voice of children, which has been a lot harder to get, but we're finally getting there with that. So that was kind of one of the problems at the time. The other thing was that quite a lot of the debate, taking a bit of a weird turn, there was a debate in House of Commons, I think in 2014, and there was a lot of good stuff said in that debate, but there was also a bit of, there was the MP who was advocating for change compared, and this was on the arguing for surrogacy change, compared surrogacy and surrogacy relationship between intended parents and a surrogate to buying a car. You wouldn't buy a car without a contract. And we in the surrogacy community just thought, what? This is not at all how we see our relationship between intended parent surrogates and the children born through surrogacy. So we felt there was a kind of undercurrent of commercialisation, an undercurrent of misunderstanding. And actually, I think there was a little bit around this commercialisation thread about actually, are there organisational people who want to change the law and potentially profit from that change in law as well? So that was quite a strong motivator. A couple of the other things at the time as well were that there were some, I think, really bad facts going, well, facts in inverted in speech marks, going around about surrogacy that just didn't seem that they could possibly be right. But yet there was no way to evidence them, to challenge them, to put forward right data. So there was a real kind of missing rigour around the debate that was happening. And as kind of mentioned, just all these assumptions and myths that were totally unchallenged and didn't know where they'd come from. And it just felt like we really needed to inject ourselves in there and start to put some structure and debate and challenge around the conversation, and to be honest, take a bit of control of it, really. So that was when we at SUK started thinking about it. And what we really quickly came to a decision as an organisation was that, yes, we wanted to really kind of put some effort into this, but we didn't want to do it alone. We didn't want to be guilty almost of what we were saying about the debate so far, that we just went out there with our own views and said, this is how it should be because we think this. What we were really keen on was actually working very collaboratively. So building a coalition of people from all different kinds of backgrounds and organisations to bring together to have that discussion. Surrogacy, especially back then, was a very small community as well. So it was how do we bring people together and find where our common points are as well as where our differences are on law reform. And we wanted that collaboration point, and we also really wanted to bring that evidence point into the debate as well. And I actually looked back on some of my early kind of emails and notes and stuff, which I know Sarah Norcross has also done. And I did find what we kind of set out as our vision. I'm not sure we ever wrote it up quite formally, so if I say this wrong, keep me real. But what I had down when I looked through my notes was that we had 4 kind of aims when we started setting up the working group. We wanted to make sure that the voices of those experiencing surrogacy, so that's intended parents, surrogates and children born through surrogacy, were heard and listened to, kind of injected into the centre of the debate. And we wanted to make sure that any calls for reform were evidence-based and kind of not based on myths or assumptions. We wanted to make sure that reform would recognise UK surrogacy as a positive and accepted form of assisted reproduction, so a positive and accepted way to have a family in the modern world. And we wanted to improve the lived experience of surrogacy and make it as accessible as possible to those in the UK who are looking to create their family in that way. So that was our kind of starting point. And actually, when I look back on that, gosh, I don't know how many years later, actually, I think we've stayed incredibly true to those values and that vision that we set out at the beginning. And the way, when Sarah talked after me about the campaign, the way that we've gone about that very much kind of mirrors those aims and objectives. So that was the kind of vision. Then it was right, well, who do we reach out to? And I'd say there's almost the kind of the core working group is being the kind of engine, really. But actually, and Sarah does a lot of this, so I can't take credit for that, but we've also really tried to reach out to other surrogacy organisations, indie forums, and we've reached out across to CAFCAS, to Department of Health, to the Passport Agency. We've tried to kind of reach everybody and give everybody an opportunity to contribute to the research that's been done, to come to hearings at the APPG. So we have tried to kind of be as inclusive as possible. But when we think about that core kind of group, really, who's taken this board and trying to push up the hill to change the law, for me, at the time, it was almost trying to hit the holy grail of 3 different types of people. One was mobilizing the surrogacy community. And within that, obviously, there's the community of people who are living surrogacy, you know, so who it means everything to us. We're, you know, surrogates, intended parents, children. But I would also include in the surrogacy community the professionals who are working in the field as well, the lawyers and the people who are kind of living surrogacy every day through their job. So we wanted to kind of mobilize that community and give it a voice and bring it together. We wanted to reach out and bring in that rigor. So the academic community was really, really important to us. And, you know, we've learned so much from all of the research that's happened and connecting in there. So that was kind of bringing that academic research element in. And then finally, obviously, we needed to start to be able to advocate within government. So we needed to start to have some advocates for us within government. So that was kind of who we were broadly looking at. We thought, if we can get those 3 things together, we can get the people with the experience, we can get people with the research and the facts and the knowledge, and we can get the people in government who are going to be making decisions. If we can kind of mobilize all those 3 areas, then we've got a good chance of hopefully achieving something. And I think the way that we started was actually emailing someone called Steve Pugh, who I think Sarah might mention as well, who is at the Department of Health, kind of the person who heads up surrogacy. And we just started spamming him. I think we organised I organised a letter writing campaign. We've got loads of surrogates and IPs to write his personal email address saying that, do we think it's about time that we change surrogacy law? So I think, bless him, Steve's been fantastic. I think he kind of thought, like, how do I stop these emails arriving in my inbox? So he then put me in touch and Sarah in touch with Sarah Norcross at Progress Educational Trust, who's been fantastic. And Sarah then also recommended that we talk to Kirsty, and that's how we've got that involved. And there was a lawyer called Louisa Gebhardt who was involved at the beginning, and more recently, obviously, we've got Andrew. And then later on, we started to get our advocates in government, like Andrew Percy through the OPG as well. So it has been a lot about those networks. It's been about bringing people together and about respecting what different people can bring to the conversation as well, and bringing all those perspectives together. So that was kind of the who. So then we had our core working group set up. We're not going to talk too much then about what happened next, because Sarah's going to come in and talk about that. But maybe just to finish, I'll talk about, well, what was, you know, we had the general vision, but then quite quickly, what were the specific kind of outcomes that we wanted to get from legal reform? So for me, well, for all of those, I think we quite quickly settled on 4 probably key areas of change that we wanted to drive. So one was obviously around parental orders, for that had to be something that was fixed. And really that was about finding a way for intended parents to be recognised as the legal parents at birth, and to be able to obviously register the birth of their children. And that wasn't just from the perspective of IP, as Sarah said, that was very much driven by hearing. And even for me, being a surrogacy community, when we sat down and had a podcast and all kinds of things at the beginning, sat down and listened to surrogates talk about why they just absolutely did not want to be seen as the mother, and they did not want that legal responsibility. So that parental order bit was absolutely key. Then the second thing that was really key as an outcome for us was thinking as well, not about just all the things we want to be different, all the things we want to change, but it was thinking about actually what do we want to protect, what do we want to keep the same, because actually the particular way that you know, the surrogacy law has created a particular culture in the UK around altruistic surrogacy, as we call it. And actually, we really felt that there were some things that we really wanted to protect, especially, and that was specifically around that kind of altruistic surrogacy as a relationship, and not a transaction. So that was a core kind of pillar. And then the other 2 things that we wanted as outcomes, we really wanted to widen access. So thinking about things like, you know, single people being allowed to apply for parental orders,
thinking about double donation, that actually couples who can't, or a single person who can't provide their own genetic material shouldn't be excluded from surrogacy. That whole kind of access, and also I mentioned when we had the question, that kind of access, financial access as well to surrogacy was quite important. And then finally, the fourth kind of outcome that we wanted to achieve was very much around better guidance around surrogacy for those going through it. And actually that's something that I think Sarah Norcross will talk about, and we had quite a lot of success in that area with government. But we also wanted better data on surrogacy and more education about surrogacy as well. So, you know, advocating more education in schools about surrogacy, and more interaction with midwives and hospitals and professionals working with those who are going through surrogacy. So that is pretty much kind of leads us up to kind of 2000, that was all between 2014, 2015 that we set up the working group. We had that vision for change. We mobilized a group of people with very different skill sets and backgrounds to come together. And we had quite a good vision, not only for the principles we were there towards, but the outcomes as well. And so early 2015, we got together as a group, and then the rest is history. And Sarah Norcross, I think, is through the timeline of what happened next. Although we didn't think we'd still be here talking about it now, did we? But
You didn't. I should probably explain that in real life, Natalie's a project manager and used to getting things done.
Yeah, in real life, we have a project, we set a timeline, and we deliver to it. That was my in 6 months to a year. Yeah.
All right. Thank you for that. So, Sarah, if you're ready and you want to share your screen.
Yep, hang on, let's share my screen. Hopefully it's all going to work. Yep, is that working for everyone?
Yeah.
Great. Okay, thanks very much. I hope there won't be too much repetition. So I've called my talk Surrogacy Law Reform. It'll all be over by Christmas, which is a title inspired by Natalie, the project manager, who thought it would all be over by Christmas in 2015. So I want you to cast your minds back, because it seems it's such a long time ago, but it's difficult to think of what was going on at the time. So you have to think David Cameron was Prime Minister. It was before Brexit, before President Trump, before COVID. And in late 2014, I received an email from Sarah Jones, in which she said she'd had a meeting with the Department of Health, and they referred Surrogacy UK to me with regard to surrogacy law. Why the Department of Health thought that I could fix surrogacy law, be helpful in fixing that rather than them, is a question that we didn't really pursue. But perhaps having heard about Natalie's spamming of Steve Pugh, this was a result of that. He thought, haha, I'll get them onto that Sarah Norcross. So then in 2015, I had an email from Natalie, very much, focused and saying that, we're going to start small, and exactly as she's outlined is that in her talk, and that is what we did. I've got a very dim recollection of us meeting somewhere. Oh, sorry about that. I've got this very skittish new mouse, and I wasn't even touching it. You probably saw my hand on the screen. Hang on, in the wrong way now. You got a sneak preview of all my slides, right? And she, we have this. I think we're in lawyers' offices. I think it was Louisa's offices, and I'd just come off campaigning from to change the law to permit mitochondrial donation. So I had a sort of appetite / time for another campaign. I'd worked closely with the Department of Health on that campaign. And at that meeting, I can remember Natalie saying she all wanted it done by Christmas, because that was the amount of time that she had with her work and family commitments. I'm going to take credit for getting Kirsty involved. She used to work at Pets many years ago as an editor on Bionews, and obviously I knew that her PhD was on surrogacy, so I knew she'd be a great expert. And I think one of the things that I was focused on the group remembering is that surrogacy is viewed by politicians and policymakers as controversial, and it's not a vote winner. It's not something that's going to get you any plaudits. It doesn't have great popular appeal, so it's tricky to get their attention and to keep them interested and get them to want to do something. And it was I very much felt that we needed to gather evidence to show why change was needed and what change was needed. And if this evidence came from the people involved, as Natalie described, from surrogates and IPs, it would be extremely helpful and persuasive, much more persuasive than if Kirsty had just said it without that behind her, or I'd said it, or anybody else, in fact. We've much more moved into a sort of evidence-based policymaking situation, and the importance of having that for the civil servants to see that actually the people who are doing this want it to change, and that there's a broad level of agreement as to how they'd like it to change. So Kirsty mentioned luck in her presentation, and we did have some luck, because Kirsty had a period of study leave coming up, and she had the credentials to do the research, and so she undertook the biggest survey, what turned out to be the biggest survey of surrogates and IPs that had ever been done in the UK, possibly the world, but I'll let Kirsty blow her own trumpet on that. And so as a result of that work, now this is where my slides go very odd. For some reason I have to go backwards. And we've had the report, which has been mentioned, Myth Busting and Reform. And in that, we laid out all the evidence. And also we came up with lots of asks, but we were very careful with our asks, and we probably give Natalie the credit for this, in that, they were very clear, focused and achievable, or things that we thought should be achievable. So, and I'm not going to read them all out, but you can see them there, and a lot of them have been mentioned already in relation to single people and birth registration and double donation. All right, let's see if these behave now. No, it always wants to skip ahead. And then a whole bunch more here in relation to them being accurately recorded by clinics and the HFEA, and the reconsideration of whether advertising should be a criminal offence, especially for non-profits, time limits for parental orders, etc. So a whole bunch of things were in there. And so we wrote to the minister with responsibility for surrogacy, with sending her a copy of our report, and Kirsty organised a conference launching the report, and there was lots of media interest around this. And there's Natalie going on to Woman's Hour to talk about it. And the little old lady, for those of you who don't know, is the late Baroness Mary Warnock, who, as I've said on my side, is the most influential person in the UK on law and ethics relating to fertility treatment. And I think that remains the case, even though she died in 2019, because it was her report which our law and regulation has been founded on ever since. Now, Kirsty and I are extremely lucky because because Mary was the patron of PET, and we had a meeting with her at her home, and we took the opportunity to discuss surrogacy with her. And she said, I do feel rather ashamed of the stance I took about surrogacy. I'm sure we could have done better. And she explained how at the time of the report, there seemed to be unscrupulous US surrogacy agencies operating in the UK, and meeting some of those operatives, representatives of those agencies, and hearing their positions, she found it very troublesome. And also, she said, personally, she couldn't imagine carrying a baby and handing it over to somebody else at that time. And so it made her and the group averse to surrogacy as a whole. But Mary, unlike many people of great importance, had reflected on this over the years and thought that that was wrong. And this was really important to our campaign, to show that it had the support of you know, the mother of our legislation. So that was brilliant for us. And the year of 2015 finished on a high when we had a letter from the minister asking for a meeting with us. So it was Christmas, it wasn't over, but we were well on our way. Months and months later, we got a date to meet the minister, but in June 2016, the Brexit referendum happened. Our much anticipated meeting with the minister was off, as there was chaos in government, plus ça change. David Cameron resigned, the minister, which is Jane Ellison, she got reshuffled. And so I think we were actually all in the depths of gloom the night before, I think. And but then all of a sudden we got a message saying, no, it's on with the new minister. And so we met the next day, we met Nicola Blackwood. We were her first meeting. I think even in the photo, you can see she was more nervous than we were. And so we had that sort of first opportunity to get in through the door and to make our points, which was good. And also the more senior civil servants happened to be on holiday. And so the minister wasn't as chaperoned as she would have been. So we were able to really shock her in a way that perhaps, well, I certainly wouldn't have dared if they'd been there. So, so it was quite handy. But we've had two ministers, and this highlights a really serious issue that we've had with the campaign. So it's a junior minister that is responsible for surrogacy and fertility treatment. And these are all the ministers that we've had during the time that we've been campaigning. Kirsty will give a prize, I don't know, a drink, to anyone who can name them all. It's a bit like naming the Seven Dwarves. I knew them all when I put them on the slide, but I've now forgotten one. So yeah, don't come to me for the answers, Kirsty, is all I can say. Some have been really supportive, others less so. But it wastes so much time because each time the civil servants have to brief them, they have to meet, they have to, we try and, get in there and talk to them and get curry favour, get support, get them to at least get what the problems are. So yeah, that's been difficult. Now, there has been one person who's been pretty much a constant throughout, and that is Andrew Percy, MP. He had a brief leave of absence when he became a junior minister, but he didn't like it and he went back to the backbenches, which was hurrah for us, because really his can-do attitude, his energy with the APPG and his trusty aide Kasim have really helped with the reform agenda. And I think, I think it's fair to say we wouldn't be where we are without him. So that's been really brilliant. But back to 2016, because it's difficult to keep this in a chronology, really. There was a debate in the House of Lords about surrogacy, and also Kirsty, Natalie and I had a letter in the Times about the issue as well. And what was great about that debate in the House of Lords was that we all got a shout out, Kirsty, Surrogacy UK and PET. So that was brilliant, but it's not about us. The most important bit was about the undertakings from the government spokesperson. And so there were three main promises that were made: that the Department of Health had produced guidance on surrogacy, that single parents would get the same right as couples in relation to parental orders, and that the government had asked the Law Commission to review surrogacy as part of its 2017 programme. So we were feeling positive. It was almost Christmas. So then we go on to 2017. There was a consultation by the Law Commission as to what projects they should consider next, and we mobilised everyone we knew to say surrogacy. We were very lucky in that the family division judges, I think also, I see you saw my hand there. My mouse has got a mind of its own. Don't know how that happened. So yes, and so we did that. And then in December 2017, a remedial order was laid before Parliament, which paved the way for single parent people to get the same rights as couples in relation to surrogate-born children. And it was Christmas again. 2018, so back to the promises made in 2016. The first DHSC guidance on surrogacy was issued. Now, guidance sounds like surrogacy pathway, really boring. But actually, I think this is a huge milestone. It's something we'd called for, but it also showed a proper government commitment to surrogacy. It gave it the imprimatur, really, of as being a legitimate means of family building. And I think it meant as well that those working in medical settings needed to think about this and try to raise their game. We didn't want to see any more babies being handed over in car parks, thank you. So this was a really important piece of work, and that took a lot of meetings, I seem to remember. Also in 2018, the HFEA included surrogacy for the first time in its published data. So that was good, and they started to put it in the code of things about it in the code of practice. So this is all, positive, small steps, but all moving in the right direction. Then in 2018, it was announced that the Law Commission would review the law around surrogacy. Hurrah. So we are very, very positive about that. Also in 2018, we had a meeting with another minister, Jackie Doyle-Price. And so we were continuing to have influence there. And it was a very, I suppose, active year in that also the APPG had 5 evidence sessions, having, Uncle Tom Cobley and all in the room talking about getting so that MPs and members of the House of Lords could ask them what they thought should happen. And so this was all very, very positive. So the next thing, of course, in 2018 was the second report of the Surrogacy UK Working Group. So that was published in December 2018. It was another Christmas. Early in 2019, the remedial order went through, so the single people thing was a tick, so that was great. And then in 2019, the Law Commission launched their consultation on surrogacy. And what a huge tome that was. So we'll let the next speaker talk about that, Spencer. And Spencer probably won't be too pleased to see that. Ages ago, I did a screen grab from the Law Commission website saying that they expected to produce their final draft and recommendations early in 2022. It's now November, and it's not promised till spring 2023, but anyway, we'll leave that to Spencer to explain. Now, during that consultation period, Sir James Mumby, who's already been mentioned, very influential senior lawyer, wrote an article for Bionews about the need for reform. And we had another Christmas. In 2020, there's a debate in the House of Commons organised by Andrew Percy. We had another minister then, we had Caroline Dinenage, and she was great. She was really engaged. She was brilliant, but alas, she didn't last long. And it's a bit like an episode of Grand Designs. When you see something in early 2021, you know what's coming. Then it was the pandemic. And that made things pretty tricky. There didn't seem much point lobbying or doing any campaign work, because let's face it, the Department of Health had big problems to deal with, and we weren't really going to get much airtime, or there was absolutely no bandwidth for us. But instead, work then focused on writing up the all-party parliamentary group surrogacy report and getting that published. And so that was published in October 2020, and then we launched it because of the pandemic and lockdowns and all the rest of it, and that's a misery they're all trying to forget now. We had a launch meeting of that, and the keynote speaker at that was yet another minister. So that was another coup for us, that we'd still got this ministerial support. So we've been very active over time, and we've been doing milestone after milestone, I think, in making things happen and keeping people engaged. And this year, PET did a Ipsos with some research with Ipsos entitled Fertility Genomics and Embryo Research, Public Attitudes and Understanding. And we asked more than 2,000 members of the public, representative sample of the UK population, a whole bunch of questions, including some about surrogacy. And you may be amazed to find out that of all the questions that were asked, the surrogacy ones were the most controversial ones to Ipsos. They wanted us to take them out. In their view, that was more controversial than embryo research. Anyway, we got our own way, and we had the questions in there. And so we asked to gain understanding of what people knew about the law in the UK. And I think we were really shocked actually that only 26% of the respondents identified that surrogacy is legal throughout the UK, and that 15% thought it wasn't legal anywhere in the UK. So it really does show that, you know, you do get inside your own bubble with these things, and a lot of people, you know, about more than a third of people admitted they didn't know the answer to that question. So there's a lot of work there to be done. And then we asked a question about compensation and expenses and payment, and we gave people a range of options to choose from. And it was interesting to see that the most commonly held view was that reasonable expenses should be paid to surrogates, and that, you know, but still a lot of people, but fifth, answered don't know, and some people thought they shouldn't be paid at all, and that was more popular, I think, with men than with women. So those are some sort of key findings that we made, and again, you know, all this is sort of very helpful in building the picture. And Kirsty and Sarah Jones both commented on those figures in the report, which is free to download. And so I just wanted to do some thank yous, as well as to Sarah and to Andrew, who I've not pictured on the slide, and all the media volunteers. There's so many people who've helped over the years, and a huge thank you to them. But this guy is Steve Pugh, the lesser spotted Steve Pugh from the Department of Health, who's been a constant in the campaign and has been incredibly supportive and helpful. Andrew Percy, who I've already mentioned. And then I couldn't find a picture of 3 women with one with red hair. Sorry, Kirsty. So it's me, Kirsty, Natalie, and me. I do have a yellow hoodie. I should have put it on for this afternoon, shouldn't I, really? And I'm just hoping that we don't look like this by the time it actually comes. And, you know, when Natalie said she wanted it all to be over by Christmas, I don't think she actually said which Christmas, but perhaps the next speaker, Spencer, can tell us which Christmas we should be booking that table in a bar to celebrate. So thank you.
Thank you, Sarah. So I think, I mean, I don't know if I got this wrong, but we are running ahead of time, I think, which is bizarre. So I'm hoping that Spencer is ready to speak. Are you, Spencer? There. Good.
I am indeed, yes.
Right, let me pin you, because that's what we didn't do last time.
Oh, that sounds painful.
I don't know how to. Oh. Yes, so like, it's showing my age. I'm bringing up the young people to do the computer thing. Oh, she's good now. Does he have a screen?
You're young still, Kirsty. Come on.
Thank you, Spencer. You haven't got slides, have you?
No slides, just
All
my
right.
face.
Awesome. Well, your face is more than welcome, Spencer. We hand over to you.
Well, I'm not sure about that, given the slight bashing the Law Commission has received from Natalie and Sarah, which I can understand and sympathise with. So Kirsty's asked me to speak about why the Law Commission included surrogacy in its then 13th programme of work, and then what we've done since, and I think primarily focusing on how we've worked and engaged with stakeholders, particularly SUK's working group on law reform, if I've got the right title. You really do need a catchy acronym. And also other campaign groups and academic research. So I'm going to focus on that. I'm not going to talk about our proposals, because I feel like I've droned on about that on many occasions, and you can have a look at the consultation paper, or perhaps more realistically, the summary thereof, because it is, as Sarah alluded to, a weighty tone that you could use to disable a burglar should you so wish. I will address the sort of elephant in the room of the time that we've taken to do the project. I mean, all I can say really is that we've been working tremendously hard on it. The pandemic was a factor in terms of the way we work. We're also doing joint work with the Scottish Law Commission. Sorry, just make sure the lights work in here. So it has taken us longer than we'd hoped, and we're sorry about that. We are committed to a spring 23 deadline, so by Christmas 23 you will indeed be able to have your celebrations, hopefully. Obviously it depends on government taking on board our recommendations. That's not within our power, but it is within our power to get the report out. So we are working very hard on doing that, and I'm spending obviously all my time on that. So I think if I move on and just talk a bit about why we included surrogacy in the programme. As Sarah alluded to, we asked about the area in the public consultation we did in 2016 on the kind of work that the Law Commission should take on. So that was across the Law Commission rather than focused on family law. Surrogacy, we suggested that, and we actually got, I think, our highest number of responses. Well, I think it was surrogacy and dangerous dogs. They were sort of more or less tied. So we went with surrogacy. So I think we got about 340 responses, which is pretty good on a kind of public consultation on what kind of work we should be doing. The reason we took it on is that we could see that the law was in need of reform, and we could see there was a general view on that. So there was the need. People have already covered this really, but the areas are sort of insufficiently regulated. There's need for an application, the application for a parental order. We knew that there were calls for legal parenthood to be available at birth to intended parents, supported by surrogates. And there was also a kind of concern around lack of clarity from some quarters around payments. Can everyone hear me okay?
Yeah.
Okay, sorry, I've now got a picture of someone in a hat on the screen, but that's fine. And importantly, and indeed vitally for us, this was an area where government was also keen for us to do work. We've heard about Steve Pugh, who is still in place, pretty amazingly, for a civil servant in the central department. So he is still very much on the project, and I continue to have regular meetings with him. So we can only take on work in the Law Commission where the necessary government departments, that's the department with policy responsibility, in this case, Department of Health and Social Care, gives a sign off and says, yes, we do have a serious intention to proceed with law reform in the area, so you can go ahead and do work on it. And in this case, they also funded it, as I think has been mentioned. I think we felt that it was an area where we could add value in terms of our independent status. We've got our USP, I suppose, is our focus on consultation. And we felt that there was probably likely to be a greater willingness of important stakeholders to engage with us than they might do in a central government department, that being our experience in general. So it made it through the programme, and we took the work on and began the project in earnest in May 2018. We had been keeping a sort of watching brief from about 2016 to the time the project began, looking at the kind of steps that have already been mentioned, the work that Sarah and Natalie and others have been doing. We were aware of all that. We'd attended an international conference in Hong Kong in September 2016, and we'd have the sort of occasional meeting with stakeholders, which then began properly in earnest once we reached May of 2018. SUK was certainly obviously been a very key stakeholder. We were aware of the 2015 report on myth busting and reform, and had read that. And then the later 2018 report was obviously very helpful. I think we first met, I was looking back, I think we first met Surrogacy UK in around July 2018, so very early on in the project. And SUK were very helpful in putting us in touch with surrogates and intended parents to share their stories. We also asked them to promote the consultation in 2019 to their members, which they did very ably. and some members of the team, sadly not myself, attended, I think, 2 Surrogacy UK annual conferences in 2018 and 2019, which is also really helpful. Also, obviously, as is mentioned, I think Surrogacy UK are the secretariat for the all-party parliamentary group on surrogacy, and that was also a very useful link into the APPG, and we attended the launch of the APPG and evidence sessions and other meetings. And then we also, moving over to sort of Kirsty very kindly let us use her conference in June 2019 to launch the consultation paper. And we'd also previously been involved right back in May 2016 in an earlier conference that Kirsty had organised. So there was a lot of connection between us and Surrogacy UK as a key stakeholder, and Kirsty as a key academic stakeholder. What I wanted to move on to was a sort of bit of a different tack on maybe gaps in engagement and kind of lessons learned as time has gone on. During the pre-consultation paper stage, we did try and engage as widely as possible, and obviously the purpose of the CP, the consultation paper, was to reach as wide an audience as possible. And we were pretty satisfied with that as far as we could see, given that we received a lot of media coverage. Our commissioner, Nick Hopkins, appeared on the Victoria Derbyshire show, where he did get a bit of a savaging from, I think, Julie Bindle. We were covered on the Today programme, Emma Barnett on 5 Live. We had some coverage on BBC Scotland on the 9, and then the Daily Mail, Guardian, Telegraph, Independent, Times, Metro and HuffPost all covered the launch of the consultation paper. So our comms manager was very happy with that, and we had a tweet that received 50,000 impressions. I don't know what that means, but it sounds impressive to me. Basically, we were pretty happy with the reach that we were getting with the work that we were doing. However, something that has emerged that I thought you might find interesting during the consultation period and then subsequently is around the attitude of some women's rights groups and some feminist groups to surrogacy generally and the consultation. So during the sort of period leading up to the launch of the project and in the work that we were doing up till 2019 when we did the consultation paper, it didn't seem to us that there was a huge amount of interest in existing women's rights groups as far as we were aware in surrogacy. As Sarah Jones has mentioned, we were aware that a lot of surrogates see themselves as, you know, having strong feminist leanings, and we were aware of that. We did try and engage with women's rights groups in particular, such as the Fawcett Society in England and in Gender in Scotland. That said, there was sort of polite interest, but there didn't seem to be a sort of burning desire to engage with us on the issue before. The general view was, we'll wait and see your consultation paper. Thanks for getting in touch, which is what we did. At that time, the more vocal groups around surrogacy, aside obviously from people with an personal interest in surrogacy or in surrogacy reform, were really from around religious groups. So we had some meetings with certain religious groups who tended to either oppose surrogacy generally or oppose reform and said there was no need for reform to happen. That isn't a sort of blanket policy amongst religious groups. For example, we had quite some dealings with Jewish groups, such as Jewish groups in Scotland and England, and they were generally very positive about reform, but other religious groups less keen. So that was where we were when we launched the consultation paper. That was our broad understanding of the landscape in which we were operating. That all changed radically during the consultation and afterwards. We received many responses to the consultation from which were based on a template response prepared by a group called Nordic Model Now, which I should probably explain as it's a bit difficult to see the connection with surrogacy just on its face. So Nordic Model Now are a women's rights feminist group advocating for the Nordic approach to sex work, which is a particular approach to sex work in which the focus is on criminalising the men who use women for sex work rather than generally women who are sex workers. Their argument was that surrogacy is a form of sex work, and therefore we should be looking at, generally they're opposed to surrogacy. Sometimes it's framed in terms of opposition to commercial surrogacy particularly, but I think generally there's an uneasiness around surrogacy and the position of surrogates. That was a viewpoint that we weren't aware of prior to that, as I've said. We hadn't noted any pre-existing interest from those groups. However, it came across very, very strongly in the consultation, as I've said. And so we then took further steps to try to engage by doing a sort of trawl of women's groups that we should get in touch with, women's rights groups. So we did a big mail out to women's rights groups, any kind of groups that we thought might have an interest, to try and fill what we perceive to be a bit of a gap in our knowledge around that. So like Rights of Women, Muslim Women's Network, Miscarriage Association, Maternity Action. There was a long list of people that we engaged with, including the British Pregnancy Advisory Service. And then during the last couple of years since the consultation, we've had several meetings with groups who are, as I've mentioned, generally hostile to surrogacy and to our reforms. So that includes the aforementioned Nordic Model Now, Stop Surrogacy Now, which is more easily understandable, Women's Place UK, End Violence Against Women Coalition, NIA Ending Violence, Object, and the Centre for Bioethics and Culture. These are generally UK-based groups, with the exception of the last one, who are US-based. And that's been something that I think is a lesson for us in terms of making sure that we don't exist in, somebody mentioned the surrogacy bubble just now. I think we may have been guilty of existing in something of a surrogacy bubble ourselves at a certain point and not realizing there were these other voices out here. I think the difficulty with the engagement with these groups is that generally what they're seeking is the prohibition of surrogacy, certainly of commercial surrogacy, which we generally don't have in this country, as we've heard. But also, I think ultimately they're not comfortable with the idea of surrogacy, even altruistic surrogacy at all. As we've always made very clear in our engagement with those groups, and I think was clear from the beginning of the project, it's not the Law Commission's remit, and it couldn't be the Law Commission's remit to decide whether surrogacy should continue or not, or should exist or not in this country. That would be far too weighty a social policy question for a bunch of lawyers to be deciding on, and would indeed be one for the government. So we've always been clear that our project starts from the point that surrogacy is an accepted part of family building. Witness all the work that Sarah and Natalie have talked about. In particular, the clearest signal from the government was the publication of the guidelines that have been referred to by the Department of Health and Social Care, which applied both to, there was one set of guidance for surrogacy generally and intended parents, and one set of guidance for the health for the NHS and people working in the medical professions. So we've always been clear that that's the route that we're starting from. So prohibition was never within the scope of the project, but it's been sort of salutary to understand that there are these voices there that do have these strong opinions. I think the way we've approached it is to, we've always been very open to meeting with these groups, and we wanted to understand the root of their concerns, and then have a discussion about, okay, you're not very happy that surrogacy takes place, but how a sort of proper regulation of surrogacy in the UK could meet some of those legitimate concerns. And we've had some really quite constructive meetings with those sort of groups. So I just wanted to give you a flavour of a sort of another voice in the debate and how we've dealt with that. And indeed just a bit of a flavour of how we've engaged, particularly with SUK and academics such as Kirsty. And so that's me. I've only gone on for 16 minutes, but very happy to take questions.
Thank you, Spencer. How do I get everybody back now? That's what I need to know. Oh, how do you, Zaina? How does it feel like that?
Like enter.
Is it that?
Yeah.
Yeah. Okay, so I will open the chat when I work out how to do it.
Is that it on?
How do I set the chat? Sorry, people, like technology, like this.
Anyone's actually asked a question in the chat yet, though.
No, but that's because they can't, because it's closed.
Need to go to more. Go off this.
You're there. I'll see it. It's like, doesn't give me an option. We have questions in the room and then I'll talk this one. Yeah. So any questions in the room first is the question from here. Thank you, Rachel.
I guess this is a question for everyone, but I'm thinking a lot about evidence-based policymaking, because I think that's been sort of thrown around by a couple of different speakers. And I'm sort of thinking about whether evidence is enough in some cases. So there's been some literature, particularly in sort of policymaking field, that talks about how we're moving on beyond evidence-based policy, and that actually the role of ideas and a persuasive idea in policy is actually sometimes more important to policymakers than the evidence. And I was thinking about Sarah's slides about myths and whether some of those myths sort of get fed into the policy making, particularly by those that sort of opposed to surrogacy. So I'm just wondering if you guys think that actually we need more than evidence in certain circumstances to get the policy over the edge, and how we might combat some of these quite harmful ideas that we see perpetuated again and again in the media. So that's for everyone and anyone who wants to say anything.
I could go first on that one. I think instinctively we have followed the approach that you probably just described. I think even though we've come from that evidence base, we had to have that as a more than a hygiene factor, but without that we wouldn't have got anywhere with the conversation. But really what made a difference was actually more the hearts and minds type engagement that we had with the individuals. So actually, in particular, when we've met with the many different ministers, one of them that you can just see something change when they speak to people like Sarah. When we've had a group of surrogates in the room who have exactly what you said, dispelled myths and just changed their whole perception and outlook, and they've had that more emotional connection, and they've had a dispelling of a myth, and they've heard something in someone's own words, you know. So we've done quite a lot of that at the APPG meeting. At the launch, the original launch, we had people coming with their children. There's a really hilarious picture where one of the kids is lying on the floor in the middle of you know, the big group of people. So we kind of walking around playing. Yeah, exactly. So we kind of brought the reality of family life for those who've gone through surrogacy, of what surrogates feel about what they're doing. And we have really led with that, as well as also having the evidence base. So I think we've kind of taken a multi-pronged approach.
And to feed on from that, certainly when we brought teams to see people, so intended parents who worked with surrogate and the child that came from that relationship, when they, you know, were present and together as a group, you know, we got the comments, oh, I get it now. I didn't get it until I could see it. You know, they didn't really understand how I as a surrogate could interact with this child and then not be something there. And it was only when they saw it as a collective, as a group, that they actually, oh right, oh that's how it's working. So you can, you know, have all the evidence that you want to, you know, stats and etc. But actually being able to see that really helped, I think.
Thanks. Building on that as well, I think not just everyone thinks about a relationship between the surrogate and the child, but I think what in Claire's example probably also surprises people is that massive bond between a surrogate and her IPs. You know, that, and actually that is the main relationship, isn't it? That is the real glue for a surrogate relationship, and just that relationship and looking out for each other and that kind of mutual team bonding that exists. I think that was a massive thing.
And I'm going to go one further. Okay, and the surrogates' children, the intended parents as well, their relationships pretty key.
Sarah Norcross, did you want to jump in?
Yeah, just to say that, you know, the evidence is a really important part of the piece, but it is just a part of the piece. Because of the myths that Sarah outlined, we needed to address those, because at the time it was, there was all sorts of things in the press, like, nearly everyone in the UK was actually going to India for surrogacy. There were hundreds of, it was, the figures were going, all the national newspapers had different figures. No one had a handle on it really. And also, I think in terms of when you're asking for change, you need to know that the people that are going to be affected by the change or have the lived experience are going to be in broad agreement about what those changes should be, because it's not very appealing either for the Department of Health or for the Law Commission to think, right, we're going to ask and we're going to get 200 surrogates are going to say, come up with 50 different quite unreconcilable solutions, and then the IPs are going to have 50 other different ones, and this is going to be an absolute headache, because surrogacy is really difficult. Because there are so many parties involved with competing rights and interests, and then also there needs to be the thought about, and what about the children, because that is something that is really important and must never be lost sight of. But as the others have said, that human interest, that those personal meetings, those letters and trips to MP surgeries that people have done have all played a really important part as well. And I think that the thing with, ideas and surrogacy is, we were going in with a very big idea that, to unpick a massive part of the law, that the person who gives birth should not be considered the mother if all these other things are in place. And that is huge. That is a massive idea. And so, we needed really strong evidence to back up the idea.
Thank you. Anyone have anything to add? Anyone else? Andrew or Spencer, no? I mean, can I just add something to that, which is about like what happens next? So if this, when the Law Commission does publish its draft new legislation, and that gets it, so obviously we need a government to give that time, we need to get that into Parliament, we need to get it debated, and that work's going to start again, because we're going to need to engage MPs, because Sarah will know from back on the debates on the Human Fertilisation and Embryology Act, like MPs, until they see this, until they know this, they don't really know what this is like, and so somebody needs to tell them. So we're going to be writing parliamentary briefings, we're going to be meeting MPs, we're going to be trying to get the APPG to expand and holding events so we can do that, because we need to inform the MPs who might be debating this what they're debating about. Because otherwise they're going to come in with myths and assumptions and whatever. So that work hasn't stopped yet, which is
We're gearing ourselves up, aren't we, again?
Here we are gearing up again. Zaina, I think you had a question, didn't you?
Yeah, so earlier it was said that you had engaged with a wide cross-section of surrogates and like tried to get as diverse a group as possible for different views. One thing that always comes up with surrogacy myths is, or like, so there are some stories of surrogates regretting their decision, wanting to keep the baby or something like along those lines, or having a horrible experience. And yet their stories aren't necessarily as amplified in kind of the different kind of evidence bases that have been used so far. How did you go about trying to engage with them, if at all? And were there surrogates who did have negative experiences that did come forward?
So it's hard to try and reach everybody, but we really did try, and the main kind of ways that we did that, we have quite an active social media, but I have to say that kind of surrogacy bubble, we're probably still in a surrogacy bubble even without social media and things like that. We did loads of media. I know Spencer talked about the media that the Law Commission did. So we did try and get out there. We had a big article in the Guardian, didn't we? We were on Women's Hour. I think we've been on Women's Hour like 3 or 4 times. We've been on the Today programme. So we tried to do a lot of publicity. We also really did, and Sarah did a lot of this, reached out to other organisations. So it wasn't just perpetuating our own SUK community. You did a lot of work to reach out to independent Facebook groups and use those networks to get out to as many people who weren't kind of in the formal service community as possible. So we did everything we could. Did we get to everyone? Probably not, is the honest answer. But I don't know what else we could do, and you know, there's going to be a second round. So if anyone does have any ideas, we're open to hearing them. And you know, the reality is, yes, there are some bad experience stories, absolutely, and where we those, and you know, some are in the case law as well, so they're there, and where we have had those views, we've absolutely represented that as well. But the reality is, they are exceptions, so you know, I think actually they probably do amplify more than the good news stories, but they are exceptions. But yeah, you know, ultimately we want a reform that protects people as much as possible. I don't know.
We did, APPG recently met with Stop Surrogacy now, for feedback from them, because that, you know, they wanted to talk to us about people that suffer with surrogacy regret. I'm not saying that these people don't exist, because anybody that makes a big decision, there's going to be a portion of those people that have regrets. So for us, it was really, we wanted that feedback, we wanted that information, even if it was anonymised. We didn't obviously want to put his names or anything like that, but we wanted that anonymised, and that wasn't forthcoming from that group. But we will continue to make connections with people that actually oppose surrogacy, because we need their feedback, we need their critical eye, because it's all really useful for us as we move forward. We need to know what people perceive are the problems, so that we can put safeguards in place so that those problems don't occur. So yeah, I mean, I like engaging with people that suppose surrogacy. I don't know if they argue. No, never argue. But it is really important to.
I was going to say as well, but like for the original APPG evidence sessions, we did invite prominent anti-surrogacy campaigners, and so there was some discussion from other people about problems they've encountered in surrogacy, but that was largely related to hurdles they had to overcome to get there, or what drove them to have to go, or at least to perceive they had to go and do it overseas or whatever. But the anti-surrogacy could only give us examples of overseas, and there were no concrete examples of anything that happened here that they could produce, and we were asking for them. We really we wanted to hear that, because we think that, I mean, that has to be part of the story too. But as Natalie says, it seems to be the exception rather than the rule, and the majority is like the things that go really well, you don't hear about, do you? But you know, and as Sarah had said, you know, all big life decisions, some people regret them. You know, lots of people regret getting married, but nobody stops people doing it. Which is something good. Yeah, and just getting pregnant. Yeah. So, Pamela, did you have a question?
I was interested when I was thinking about the myths, because one of the myths is that somehow offshore surrogacy is bad. That's where, in contrast to the UK model, but yet there are a lot of individuals who go abroad, and they continue to maintain contact with the surrogates. And I was wondering if that was also come to the table either in your consultation or up to Spencer, and just to counter that myth, because I think that that's part of the anti-surrogacy movement. They do see what happened in Thailand or India, and consider that that's what always happens, but that's not the case. I mean, I've talked to many people as a Canadian. I've talked to many people who have gone to Canada and involved in a research project in Canada on this, and I can see from that there's continuation of contact. Yes, we don't live a train ride. The surrogate doesn't live a train ride away, but doesn't mean that there is not contact.
I agree with that. And you know, I think again in the APPG sessions we had people who had done surrogacy in other countries, so it wasn't just UK surrogacy. We had an organisation who facilitated arrangements across multiple countries coming to talk about experiences. So we definitely gave the forum to hear those voices, and you know, absolutely agree that there can be some really, really positive
No, I was just thinking of the kind of obstacles, because clearly when you're gonna come forward, you'll have a new group of people in Parliament. Some will be the same, but many will be different. And media's changed a bit. I mean, social media is very quick, it's very vibrant, and these groups coalesce very quickly. And I was just wondering what you sort of see on the horizon in terms of how you may have to change your media strategy, or what some of those new issues might be that that either your research will give you some highlights about or insights to, or how you want to strategize what's going to happen in the next 12 months.
Hopefully, hopefully. That's 2 Christmases. Yeah, well, I don't know about that. Before that, Spencer, did you want to say anything about engaging those groups, or did you think you said enough about that?
All I would say is that we're obviously in a different position to Surrogacy UK. Your role is to lobby for what you see as the right outcome. Our role is to take as far as we can an impartial view and make sure that everyone feels included in the process, which is why I was sort of drawing attention to the work we've done recently with groups that are hostile to surrogacy. So I suppose, yeah, just to reiterate that we want to make sure that all voices are included, because I think there's no point in sort of seeking to exclude people that are hostile to surrogacy. It's better to sort of hear those views and try and take the good points from them. They do make some good points. And then sort of go forward from there, really.
Sarah, did you want to come in on strategy for the next 12 to 18 months?
I think it's very hard to predict, because we don't know what's we haven't seen Spencer's homework, so we don't know what's coming exactly, and so we don't know how, hopefully we'll be giving it a lovely, warm reception and just saying, yeah, telling the government just do what Spencer says, and pass the bill and don't mess around. So that's, there are too many, I think questions. I think in relation to Pamela's point about, overseas isn't always bad. Overseas can be fantastic for people. But we know that there have been issues overseas, but also, going to California, it is great if you've got quite a lot of money. It does seem to be sort of rather expensive. So, that then prices people out. But I think part of the work that, looking at this is, has been thinking about, well, what countries do it well that would be, that we could have reciprocal arrangements, with that they can be fast tracked, etc. So, so somewhere like, it's certain states in America good, and Canada good, and places that as the pop-up shops, as Kirsty described, where there's perhaps just a legal vacuum, then bad, to try and disincentivize people. But ultimately, we can't, however fantastic the new law is, we're never going to be able to stop people from going overseas to do this. We don't want to live in that type of country where we ban people from traveling because we suspect they're going to go for surrogacy, because we don't really know. So I think it's it's those sorts of things, and having sort of incentivizing people to stay at home if that's what they want to do, and to and I think it's telling that so many people didn't know that surrogacy, there's law and regulation around surrogacy in the UK, and has been for over 30 years, and I think that is, it shows that the amount of work there that there is to be done, and people, when they get very desperate, don't they sort of jump about on things and don't really, or not all people engage that sort of rational part of their brain. I don't know whether anyone reads Alison Motlock's blog about Ukraine, and there's an interview she published this week with somebody who has set up a new surrogacy arrangement in Ukraine at the moment, and and the intended parent, he thinks the war will all be over very soon. And it's all a bit of something and nothing, and it is, which is quite astonishing. So if you don't read that and subscribe to it, I'd recommend that, actually.
And it's interesting as well that in the 2015 and 2018 surveys we had a lot of people. So that by far the biggest group of people who responded were UK based, but we all have the UK based surrogacy. But we did have people who went overseas, and a lot of them, you know, when answering the survey questions, said they'd been overseas because they didn't know that. And these are people who had engaged with surrogacy because they are not the general public that was in Sarah's poll from earlier this year. People who had engaged in surrogacy still didn't know it was legal to do it here, and that's why they went to California or India in many cases in the survey because of the dates of the surveys. And so they went to places where they did know it was legal. So that was, you know, that was a thing. So the two key themes that came out of the people who went overseas who responded to those surveys were going to somewhere where it was legal and they knew it could happen, and the perceived certainty of coming home with a baby, as opposed to the uncertainty or possible illegality here. And so it does seem like there's a sort of education base, which is why one of the foundations of our early recommendations was about having surrogacy onto education in schools about families and relationships. Which I mean, I can tell you from my kids, I grill them all the time. You know, what did you learn about in relationship and sex education or whatever it's called these days? And they're like, oh, well, you know, like we put a condom on a banana. And I'm like, good, still doing that. Still doing that, but not telling people. So I mean, people, it's very rarely that any child in school learns about infertility. That it's all about preventing pregnancy. That's what you're telling teenagers. As opposed to the fact that actually some people can't have families, or that there are different kinds of families. There's a bit more of it coming through, but it's not a lot.
Spencer had his hand up as well.
Spencer? Oh, he has like a proper hat, a Zoom hat.
Yeah.
Go on, Spencer.
Yeah, I just wanted to come in on the international surrogacy arrangements point. I think our position is actually there is a sort of value judgment to be made around international versus domestic. One reason being that obviously, as the Law Commission, what we recommend, we can't make recommendations that affect what's happening in other countries, really. So if we're trying to put together as what we see as a better system for surrogacy, we're necessarily going to be doing that on a domestic basis. So there's that. So I think one of our avowed policy aims is to try and, as I think Sarah put it, to try and sort of bring surrogacy back into this country and incentivize people to want to stay in the UK to do domestic surrogacy arrangements rather than go overseas. As well, I think one thing we do know is that up to half of surrogacy arrangements do take place overseas, or at least that was the position perhaps for the Ukraine conflict. So that is a kind of stated aim of ours, I think, to sort of incentivize surrogacy happening in the UK and to create a system that works towards that. And I suppose there is the big question of, yes, I think I'd agree that there are some places internationally where surrogacy, there are very good best practice around surrogacy. So, for example, some Californian agencies. There are some places where it's pretty bad. We visited Ukraine as part of our research, and there were, even before the conflict, real problems with surrogacy in Ukraine in some cases. And I suppose the ultimate thing is, surrogacy abroad is nearly always commercial surrogacy, with the exception perhaps of Canada and perhaps a few other places that I'm not aware of. So if we have a commitment, for example, to non-commercial surrogacy and to altruistic surrogacy, then necessarily that involves either going to another country where that's possible, and that doesn't really happen in many places, or our preference would be to incentivize it happening here. So I think there is a kind of value judgment to be made and a sort of policy choice to be made, and that's something that we're looking at and will become evident, I think, from our report.
Thank you. Andrew, I'm conscious you've been very quiet. Does anything you want to say?
No, not really. I kind of echo what Sarah said earlier. I mean, I think in terms of, policy, in terms of trying to create an incentive for people to embrace surrogacy in this jurisdiction, ultimately it will still come down to choice, and people will still go abroad if that's what they want to do. But it's giving people options, isn't it? That's got to be key, and making it safe and easier. And because ultimately what people want is certainty. And I think what the research tends to kind of indicate is that one of the reasons why people don't feel comfortable with doing it in the UK is that lack of certainty. And so proposals that hopefully will form part of the bill that would allow a particular pathway to enable parenthood being afforded at birth would create that sense of certainty. So I suppose much of it is kind of all in the Law Commission's hands, no pressure, Spencer.
Yeah, I mean, I find it weird that the certainty is linked right back to the myths that, like, the certainty people want is that they're going to become the parents of this child. And what's in the back of their mind is that because the surrogate's the legal mother, she's necessarily going to want to keep the child and run away with it and deny them this opportunity. And that create, it must have been, I mean, it's not been in a situation, but it must have just created niggling uncertainty. Because the reality is that doesn't happen very often. Or it's certainly, you know, and as Sarah said earlier, that the you can count on it, you know, on fingers one hand the time that's happened, and it hasn't always happened because the surrogate wants to keep the baby. It's happened on a couple of occasions where the surrogates have concerns about the intended parents, and there's more like a, oh, hang on a minute, should I go through with this? Not, oh, I'm desperate to keep the baby that I've been pregnant with. And it, you know, so I find this feeling of uncertainty weird. It's a perception of uncertainty rather than a reality of uncertainty. Because actually there is a process that, you know, there is a supportive way of going through surrogacy. There is a process by which you can achieve legal parenthood, and all of that's pretty certain actually, but in exception.
I mean, that is really, if I go back to 2008 was when we were thinking about surrogacy. And when we first started thinking about surrogacy, we thought there's no way we're going to do it in this country, because exactly that, the first thing you find out is that you're not going to be the legal parents at birth. And the first thing that jumps into your head is someone could keep our baby. And, you know, we're going through surrogacy because we wanted to create, you know, in ideas, and in our case in genetics, I think that matters, you know, our child. And that was absolutely terrifying. So actually we started off by looking at that time at surrogacy in India, but we just didn't feel that we would have certainty of that the surrogate was being looked after, and we decided that we wouldn't have a child at the expense of somebody else. So then we looked at California, America, and we decided, well, do we want to start off a family life by, you know, getting into debt and putting ourselves in a really difficult financial situation? So we said, oh, let's look at some of the UK, let's look into it a bit more. We called SUK. And I must say then, from the first event that we went to, so right up until this point where there's no way we're really going to do it in the UK, we just absolutely can't entertain an idea where someone could keep our child. That would destroy us. The moment, so that hurdle for most people is, like you say, the perception hurdle. A lot of people don't get past that. We went past that, went to an event. From that, the first moment we walked into the SUK event, which was in a pub in a roundabout somewhere, and we just started. We met surrogates at that event, started talking to people, and from the end of that event, we never had that worry again. It literally vanished from the moment that we actually met surrogates and started talking to them. And then, you know, and understood the ethos and heard surrogates speak. And, you know, by the end of our journey, we had lots of friends that were surrogates. With Jenny, who was my surrogate, when we kind of came together to form our team, there was not even a 0.00 something that she would keep the baby. It was a non-existent worry. It absolutely 100% was not going to happen. So yeah, it's that perception hurdle, and then the reality is quite different once you can get that step.
It's interesting you say that, actually, because the research I've just been doing with survey and interviews with surrogates, which is obviously interesting, and they got loads to say, but the intended parents, which I'm just writing up now, so many of them, so this is clinic based, this is one clinic's set cohort of surrogacy journeys, and I've interviewed and surveyed and interviewed the surrogates and the IPs separately. and they may not match up, so I had all their contact details, contacted them, and had a number of surrogates respond, a number of IPs respond. Who knows whether that surrogate's IPs responded or not, because they're all anonymous. But of the IPs, and in particular when I interviewed them, so many of them said we started by looking overseas and exactly the same reasons, and that we started in that, and then in the end we decided we just couldn't do that, and or we looked at adoption first, and then looked at once we started delving into adoption, we saw how hard it was, how unlikely it was, and in particular among the gay male couples. So even though it's possible for a gay couple to adopt, absolutely, in reality, it doesn't seem like many of them get very far. And the other thing is, this is about children who need families rather than a family who wants a child of their own. And so many of those children come with needs, and people were ruled out along the way because they'd be two people who have full-time jobs or whatever, and the children didn't need that. And so many of them looked at other options first. Sarah, like, why don't you just adopt? Well, lots of them looked at that first, and lots of them looked overseas first, and then come to it later. So there's quite a lot of them who came later, having done a lot of research into a lot of other things, and they came, and the relief that it is possible and it works well in the UK is palpable. I think in the interview they did, the fact that they came to this and it was something they could do, and it was amazing, and we've got our kids, so great to hear.
Another slight aspect, just a slightly different perspective as well from that, not just a certainty of outcome in terms of you you're going to get the title, which sounds like the way to say it, but when you first came into surrogacy, that's probably where your head is. But for me, it was also about the kind of the taking away of your identity as the parent of your child, just that perception. Whereas if you go to California, you're probably straight away treated, you're going to, as a parent, you're going to be on the birth certificate. I think there's that other mental barrier, is that in the UK, before you get past all that, you kind of discredited as the parent of your child a little bit. And I thought, for me personally, I found that quite hard to deal with when we first came to surrogacy in the UK.
Any more questions anywhere, online or in the room?
Nothing online.
Anything else? All right, then we'll wrap up.
I have thought of a new name for the group. It has an interesting acronym: the Surrogacy Law Action Group. There we go. Think about it. I think we can put that one in the bin.
Surrogacy Law Action Plan. What's that? Thanks, Sarah, for just on a nice high note there. Thank you ever so much, you three online, for joining us and for being messed around with train strikes and not train strikes, and train strikes and not train strikes, and online, offline, offline. And for participating anyway, and thank you for coming anyway, having been messed around by train strikes and train strikes, and everybody who did come in the room and everybody else who's online. Thank you so much. It's always good to do these things, and nice to see you all. We've all been in a place together for ages, so that's all. Even if you three are only virtual. So thank you very much. We will close it down there. I don't know what happens with the recording. It has been recorded. Darren will do something with the recording. I know there's some people who had wanted to attend, who were going to attend, and then who couldn't attend, and we'll send it to those people especially, but other than that, I don't know where it goes. And this has been part of a wider week of public engagement stuff going on across the division of law. What was it even called? Law and activist day, law something and social justice, societies and social justice. It's new. It used to just be the law school, and now we've got other things to think about. So it's one part of a larger week of things that are great to publicly engage again. Thank you, everyone. You're free to go. You can go online.
Bye.
Thank you. Thanks, everyone.
Thanks. Bye.
Bye.
And
Yeah.